Good morning. Madam Clerk, call the first case.
We begin this morning with the Rule 20 oral argument docket. Cynthia Pajak versus Under Armour Incorporated, Under Armour Retail Incorporated, and Brian Boucher. Docket number 210484. And this case is before the court under a certified question from the United States District Court for the Northern District of West Virginia.
Go ahead, counsel.
May it please the court. Your Honors, I'm Amy Smith, and I'm here today on behalf of the plaintiff petitioner, Cynthia Pajak. The court in the Northern District of West Virginia has certified the question whether an entity that does not meet the definition of employer in West Virginia Code Section 511.3d is nonetheless subject to liability under Section 511.9.7 as a person defined in Section 511.3a. That all sounds like this is going to be a question of statutory interpretation, and that would be correct. It gets rather detailed because the statutory construct of the West Virginia Human Rights Act is quite deliberate and quite specific with regard to who is subject to liability. And Ms. Pajak submits that Under Armour defendants in this case certainly are subject to liability under the Section 511.9.7, either as a person or as an employer under the statute as defined. Briefly, by way of background in this case, Ms. Pajak was employed by Under Armour in 2012. She held the position as Director of East Coast and Canada regions, and she worked remotely from her home in Bridgeport, West Virginia. Beginning in January of 2018, female employees began coming to Ms. Pajak with concerns and with complaints of sexual harassing type behavior. There were various incidents. One of them involved a gentleman employee who stripped down to a Speedo and did a sort of striptease act on the sales floor. And the female employees were concerned. They brought their concerns to Ms. Pajak. Ms. Pajak encouraged them to put those concerns into statements, and Ms. Pajak provided those to her supervisor, Brian Boucher, who's also a defendant in this case. Mr. Boucher minimized those concerns and told Ms. Pajak to move on. In June of 2018, Ms. Pajak had an employment evaluation by Mr. Boucher, and there were no performance issues noted. 9 days later, Mr. Boucher asked Ms. Pajak to voluntarily resign. He did that without consulting Under Armour's HR. Then, when she did not resign in September of 2018, Mr. Boucher put Ms. Pajak on a 60-day performance improvement plan, or PIP. It's the norm at Under Armour for it to be a 90-day PIP, and this PIP had no objective metrics associated with it. So she was placed on a PIP. During this time that she was on the PIP, other incidents came to light, such as a Wall Street Journal article that pointed to several incidents at Under Armour, and the article was called UA's #MeToo movement, no more strip clubs on the company dime. That was in November of 2018. And during this time, they're having conversations at Under Armour, and Ms. Pajak is involved in those conversations about the corporate culture. And again, these concerns are dismissed. In December of 2010, or December 10, 2018, Mr. Boucher fired Ms. Pajak when her PIP 60-day period was up. In July 16, 2019, Ms. Pajak filed the complaint in the Harrison County Circuit Court against Under Armour Inc., Under Armour Retail Inc., and Brian Boucher. Among the claims asserted in the complaint is a claim under the West Virginia Human Rights Act, and very specifically, it's a claim under Section 511(9), subsection 7, which is what they call the retaliation provision. Under Armour moved to dismiss. The motion to dismiss was denied. Subsequently, Under Armour moved to certify the question to the district court as to whether Under Armour employed a sufficient number of employees to be subject to liability under the Act. Ms. Pajak worked remotely in West Virginia. You'll see from the statement of facts provided by Judge Keeley, it's undisputed that more than 20 employees live in West Virginia and work for Under Armour. However, there are fewer than 20 employees actually working in West Virginia. I believe, if you want to think about it this way, I think many of them work at the Outlet Mall in Hagerstown, Maryland. So there's a discrepancy in the numbers. It's undisputed that more than 20 employees are citizens of West Virginia. Fewer than 20 physically work in West Virginia. But Ms. Pajak did work remotely from her home in Bridgeport, West Virginia. That was the question Under Armour asked to be certified. Ms. Pajak responded that it didn't matter if Under Armour met the statutory definition of employer. Under Armour is still a person under the definition of person in the Act, and as such, Under Armour is subject to liability under Section 9(7). The court originally determined that it would certify two questions, both of those questions essentially, whether a employer that did not meet the statutory definition could nonetheless be liable as a person, and also the question whether the statutory definition of employer required working within the state, or if it was persons in the state. Those were the two questions originally certified. Subsequently to that original order on March 5th, 2021, Judge Keeley asked the parties for help in framing the actual questions, and ultimately she determined that she would only certify the question that I presented to the court at the beginning of the argument, whether an entity that does not meet the definition of employer is nonetheless subject to liability under Section 511(9)(7) as a person defined in 511(3)(a). Ms. Pajak requests that the court reformulate the question and hold that Under Armour is subject to liability under Section 511(9)(7) as a person defined in 511(3)(a), regardless of whether Under Armour meets the definition of employer in Section 511(3)(d). And alternatively, Ms. Pajak requests that the court hold that Under Armour employs a sufficient number of employees within the state to be subject to liability as an employer defined in Section 511(3)(d).
Counsel, how do we get around to get to where you want to go? How do we get around Williamson versus Green?
Your Honor, Williamson versus Green did not frame this question, did not even attempt to answer this question. In Williamson versus Green, the sole question, the first question certified to the Supreme Court of Appeals was whether the Jefferson County Commission, I believe it was a statutory employer. The court held that it was not. There was no subsequent question. It was never briefed. It was never argued that the Jefferson County Commission could alternatively be held liable under subsection 7 as a person. The certified question next answered by the court jumped over that question completely and went to a different question, which was whether an entity that did not meet the statutory definition of employer could be held liable under Harless. We're not asking for that. We're briefing an entirely different question. And this is a question, Your Honor, that you recognized, I believe, was open in the Nelson decision in 2021. So I believe the court recognizes that this is a question people have danced around for some time. Was it raised in Williamson? It was waived in Kalani, and it was also held to be waived in Nelson. But we're here before the court today because this is an important question that needs to be answered.
And focusing squarely on the certified question in this case, when the legislature went to great care, coming up with a definition of employer, with a number of persons within the state employed, bringing the state in to the definition of employer, all of that, and then provides for employment liability under 511.91, how does it make sense to then have that employer subject to liability in its role as employer under subsection 7?
Well, the statute specifically includes employers in both subsection 1 and subsection 7. There's no question that the legislature views the retaliation provision in subsection 7 as being a very critical provision, Your Honor, with regard to each of the subsections.
But is it more critical than the definition of employer?
The definition of employer is simply, the answer is, Your Honor, that the definition, that they both coexist and can be easily read together. And so the definition of employer does have political subdivisions, and it has persons employing 12 or more persons within the state for the requisite period of time. So if you don't meet that definition, you're simply not an employer under the statute. And the statute's very clear in the definitional section. For all purposes, if you don't meet that definition, you're not considered an employer. And so the consequence is that a person that is a corporation that does not meet the definition of employer, still by virtue of being a corporation meets the definition of person. There are only two subsections that the legislature felt were critical enough to include liability against persons. One was subsection 6, which actually limits the persons to persons associated with public accommodations. But with regard to subsection 7, persons is in no way limited. All persons that meet the definition of person are subject to liability very plainly under subsection 7. And that definition does not create any kind of statutory nullity, as the Under Armour has argued, and as stated in the dicta in Kalani's footnote 13. And the reason for that is simple. The reason for that is, as was fleshed out a little bit in the separate opinions in Nelson, the definition of person does not include the state or political subdivisions. So the state and political subdivisions cannot be subject to liability under subsection 7 unless they meet the statutory definition of employer, because the statutory definition of employer does include the state and political subdivisions. So it's not a situation where the word person is some kind of catch-all that was just not considered.
Counsel, I would like to hone in on that argument a little bit. When you started your argument, you said we are going to need to construe this, correct?
Your Honor, I believe that this is plain and unambiguous, and so construe, apply, perhaps would be what the court would say, but yes, it's a matter of statutory construction.
So I guess the way then, if you say that it's plain and unambiguous, why could you not read it plainly and unambiguously that it really is saying, defining what that is, a person, but where we deal with it in the statute, it says any person, employer, or employment agency. Why couldn't you plainly read that to be any person, including an employer as defined with more than 12 or more employees? Why would that not be a plain reading of what the legislature intended? And then to accept your line of reasoning, wouldn't we have to amend that plain reading to say instead we're going to amend the reading of the statute and amend the language to redefine employer to say that reads any person or employer with one or more employees? I mean, to give full effect to the legislature and to accept that this word employer was inserted into the statute for some purpose, as opposed to not read it as a nominee. Why would we not have to engage in amending this statute, which I don't think we are allowed to do under our case law, as opposed to go back to the legislature, have them enact a new statute, amending it, and the governor signed it, as opposed to us substitute our ruling for the legislature? And I guess that's where I am honing in on trying to reduce this argument to its least common denominator.
Yes, Your Honor, and I would point the court to in section 511.97, each of the entities that is subject to liability is an alternative, and it's an independent alternative. And the way that you know that is because at the end of the list, it's for any person, employer, employment agency, labor organization, owner, real estate broker, real estate salesman, or financial institution. These are all independent choices, and we've briefed even the question of or being an alternative, and I believe that was discussed in this court's opinion in State versus Woodrum not long ago. But or is an independent alternative in this case, and the definition of person, just like all of the other terms in the statute, which some are defined and some are not in the statute, but person has a very straightforward definition: one or more individuals, partnerships, associations, organizations, corporations, labor organizations, cooperatives, legal representatives, trustees in bankruptcy, receivers, and other organized groups of persons. And the definition
Counsel,
of
if you want to save a couple of minutes for rebuttal, you probably better wrap it up.
yes, Your Honor, I would just say that the definition of employer, on the other hand, is very specific, it's employing 12 or more persons within the state. We submit that using the last antecedent rule, that within the state refers to the persons within the state, going back to the purpose of this legislation, which is to protect West Virginia citizens, and the objective that it be broadly construed to do so. But more importantly, for purposes of this, the definition of employer is a definition that Under Armour, if it's not an employer, then when you're looking at subsection 7, you don't need to worry about that second term employer, because Under Armour doesn't meet that definition under any circumstances. It says in the definitional section in the introduction, it says, for all purposes under this statute, here are the definitions.
Okay,
So,
counsel, I think we understand your position.
thank you.
Counsel, I understand you're splitting time with Mr. Kaminsky.
Yes, Your Honor.
Okay, go ahead.
Good morning. May it please the court. My name is Jill Hall, and I, along with my co-counsel and Jackson Kelly, represent Under Armour, Inc. and Under Armour Retail, Inc. and the certified question before the court. The certified question presented by the district court should be answered in the negative for 3 reasons. First, the legislature has evinced a clear intent to exempt small employers from the reach of the Human Rights Act. That's clear in the definition of employer. It requires that an employer have at least 12 employees within West Virginia to be subject to liability under the Act. Second, 30 years of precedent from this court affirm that legislative intent and hold that although an employee of a small employer does not have a cause of action under the Human Rights Act against their employer, there is a common law remedy for that plaintiff, and that is pursuant to Harless and a common law retaliatory discharge claim. And third, if the court were to accept petitioner's argument, it would open the floodgates to litigation against small employers in West Virginia, and it would eviscerate the clear intent of the legislature that those small employers should be excluded from coverage. Just to touch on the second issue raised by petitioner in terms of whether Under Armour is an employer under the statute because they have at least 12 employees who live in West Virginia, the district court agreed that it's clear that the definition of employer require that employees actually be working in the state of West Virginia. It's a geographical requirement that is part of the definition of employer, and clear that the fact that an employer's employees may choose to live in West Virginia, even though they work at another state for that employer, does not bring them within the definition of employer under the Act. And turning to the certified question before this court, whether an entity that does not meet the Act's definition of employer can be liable under the Act as a person, the answer to that question in the context of an employment relationship is no. And this court made that clear in Woodall almost 30 years ago when the plaintiff tried to avoid the numerosity requirement found in the definition of employer by arguing that the employer could be liable as a labor organization under the Human Rights Act. And the court said, no, you can't get around the numerosity requirement by reclassifying your employer as a labor organization. And similarly here, the petitioner cannot get around the numerosity requirement by reclassifying Under Armour as a person under 511.97.
Counsel, would it be then your position, correct me if I'm wrong, that these other categories, employer, labor union, those types of things, person would only come into play when there is no such relationship under any of the other classifications?
Yes, I think person is limited by the additional potential defendants that are listed in that subsection. So we know that person is limited in other ways too, right? It's the Human Rights Act only deals with employment, public accommodations, or housing and the financing or procurement of housing. A person is limited by the acts that are prohibited in the Act. But the definition of employer applies throughout the entire article, and it has to mean something, including in 511.9.7. This court said in a footnote in Kalani that it would create a statutory nullity to just read out the term employer from that same subsection and hold anybody who doesn't satisfy one of the other definitions as a person. And that statutory nullity, the court has counseled against creating a statutory nullity such as that. The definition of employer means something throughout the entire article, and any time it appears in the article, it refers to an employer as defined in 511.3D.
So, Ms. Hall, it seems to me there's kind of another way to look at the certified question. Judge Keeley wrote a very clear certified question that talks about whether an entity can be subject to liability as a person under subsection 7. But aren't there really possibly, and you referenced it a moment ago in something that you said, isn't there a possible kind of two steps to this? One, that an entity can't be held liable as an employer under subsection 7, but if it's a person and not employing the person who's bringing the lawsuit, couldn't they be liable under section 7 when it's outside the employment relationship? An example, you have a subcontractor on a site its employee allegedly sexual harasses an employee of the main employer on the site. The small contractor might not be subject to employment or to liability as the employer, but may face an aiding and abetting cause of action as a result of the actions of its allegedly sexually harassing person, if that hypothetical makes sense.
It does, Your Honor, and it's a possibility in the employment context when there is a covered employer involved. And so this court has already held in Michael versus Appalachian Heating that outside of the employment context, an insurance company in that case, for example, could be considered a person. In the Conrad case, there was a little bit of a complicated relationship among the entities there, but at the core, there was an employer, the jail authority. There was an individual liability as a person under 511.9.7 because that person allegedly aided and abetted that covered employer. But I do think that the court's precedent is clear that in the context of an employment relationship, there must be a covered employer to hold anybody else liable with respect to aiding, abetting, or retaliation that arises in that employment context. And I did mention that the Woodall case was clear about that. When a party is sued in their capacity as an employer, they have to satisfy the definition of employer. If you look at petitioner's amended complaint, it is clear that the only allegations against both Under Armour entities revolve around the employment relationship and that context. The allegations are that the Under Armour entities hired the petitioner, fired the petitioner, put her on a performance improvement plan, engaged in retaliatory discharge. They are not distinguished throughout the amended complaint or at any time throughout this litigation, in fact. And so there's nothing here outside of that employment context, and it's not disputed that neither Under Armour entity employs 12 persons who work within the state of West Virginia. I think that Your Honor mentioned Williamson versus Green earlier. I think Williamson versus Green is on point. It made clear that small employers are not liable under the Human Rights Act, and it fashioned another remedy. So petitioner is not without a remedy, and in fact she pleads a common law retaliatory discharge claim as count 1 in her amended complaint. So the court in Green recognized the policy objectives the petitioner is relying upon in her argument and said, we recognize that this is an important policy in the state of West Virginia, so we're not leaving these plaintiffs without a remedy. We're giving them a common law retaliatory discharge claim under Harless, but you don't have a claim under the Human Rights Act if you don't employ 12 people in this state. In addition, Kalani, we believe, is directly on point. The court in Kalani said that a small employer is not a person under 511.9.7. It's been argued that that case might not have been directly on point because of the facts, but what the court held was if a small employer can't be liable under the Human Rights Act, you obviously can't then hold them responsible for attorney's fees under the Human Rights Act as a person. Again, the definition of employer is found in subsection 511.97 with respect to A through C, and therefore there is no claim outside of a common law remedy with respect to a small employer.
Counsel, is it your position that Mr. is it Boucher? Is that how you say it?
Mr. Boucher, correct.
Mr. Boucher, is it your position that because he's an employee of Under Armour, he is not a person under 9-7?
It's our position that because Under Armour is not a covered employer under the Human Rights Act, that Mr. Boucher can't be held liable as a person under the Act either. And we think it would just produce an absurd and an illogical result. We know that the Fourth Circuit has spoken in the context of Title VII, which this court does look to when compatible with our Human Rights Act, that the Fourth Circuit has said that an individual supervisor, who works for a small employer exempt from Title VII does not have individual liability. We cited the case out of New Hampshire that has a similar holding, that it would be absurd to say that an employer who is not liable under the Act, that an employee of that employer can have individual liability when there's no covered employer. So it is our position that a covered employer has to be involved if an individual supervisor is to be held liable under the Act. In conclusion, before I cede my time to Mr. Boucher, petitioners asking this court to disregard the definition of employer and asking the court to fashion a new remedy, a new cause of action against small employers in West Virginia. There is not support for this in the statutory language that we're dealing with. The legislature clearly intended to exempt small employers from the reach of the Human Rights Act. There is no support for this in 30 years of precedent from this court, and as a matter of policy, the court should respect the fact that the legislature intended to take small employers out of the equation with respect to liability under the Human Rights Act, particularly when there is a common law remedy for petitioner and other plaintiffs of small employers. Thank you for your time.
Thank you. Got about 9 minutes.
Thank you, Your Honor. May it please the court. Your Honor, my name is Scott Kaminsky, and I represent the defendant Brian Boucher in this matter. And we are here before the court to request that this court, under its authority, reformulate and add a certified question that mirrors, Justice Hutchinson, precisely what you just asked my colleague, and that is whether Brian Boucher, as an individual and an employee of Under Armour, can be held liable under the Human Rights Act in a situation where his employer is not subject to the Human Rights Act due to the numerosity requirement. And to that end, I think the syllabus point 2 of the Kalani, if I'm pronouncing that correctly, case is instructive here. I could not find any specific case that addressed this issue precisely as we have framed it before this court. But syllabus point 2 of Kalani discusses whether an employer who does not come within the statutory definition because of the numerosity requirement can be held liable nonetheless under the Human Rights Act. And the circuit court in Kalani said yes, that employer is a person and awarded attorney's fees. And this court in syllabus point 2 of Kalani said no, that's not correct. The employer has to be covered or subject to the Human Rights Act in order for the employee to be liable. And in Kalani, just to dive into the facts just a little bit, the owner of the bar, the small business, Mr. Campbell, was the alleged perpetrator of the unwanted kissing and touching of Ms. Kalani. And that occurred here in West Virginia. In this case, Mr. Boucher is not alleged to have done anything within the boundaries of the state of West Virginia, and he is not alleged to have inappropriately kissed, touched, or otherwise Ms. Pajak. It is a retaliation claim. And what I think is important to my position, Mr. Boucher's position in this case, Your Honor, is in the record at Joint Appendix starting at page 467. That's the District Court's memorandum of opinion and order refusing to certify the question that Mr. Boucher has proposed. The District Court in that case, in that order, does not anywhere address the Kalani decision. Refers to a lot of other cases, but does not address Kalani. And I think syllabus point 2 of Kalani really is close to on point in the situation that we have here. And as my colleague articulated, it produces the potential for an absurd result where an employer, because of the numerosity requirement, isn't subject to the Human Rights Act, but one of its employees is. And that's precisely the New Hampshire case, the EEOC versus Fred Fuller case that we've cited in the briefs. Just as a last point, the plaintiff, in this case the petitioner, brings their case under 511-9, and particularly subsection 7. And that's the only subsection of section 9 that applies to a person as opposed to an employer. But it's derivative. Subsection C talks about engaging in reprisal for practices forbidden by the Human Rights Act. Well, if you are an employer with fewer than 12 employees, you're not subject to the Human Rights Act, and therefore how can a person fit within that definition if the person's employer does not? And as my colleague articulated, the plaintiffs in positions like this have a remedy. That remedy is under Harless. That remedy is not under the West Virginia Human Rights Act.
What's your position, Mr. Kaminsky, about whether this plaintiff, since you're asking us to reformulate the certified question, to add a question that Judge Keeley declined to certify to us, what's your position on whether this plaintiff could assert a Harless claim against your client?
I believe that she already has. And I believe that that is appropriate. We obviously deny the conduct and the allegations, but I believe that is the appropriate remedy for a claim such as this for retaliation against an individual person such as Mr. Boucher, not the Human Rights Act. Mr. Boucher did not decide to hire an employee within West Virginia. He did not decide to supervise an employee within West Virginia. And if you look at the remedies available under the Human Rights Act, most of those go to an employer, remedies such as reinstatement. Mr. Boucher, who's no longer employed by Under Armour, certainly cannot reinstate Ms. Pajak to her former employment at Under Armour. He cannot hire her back to her former employment at Under Armour, and he cannot pay her back pay from her former employment at Under Armour. Those are all remedies designed towards an employer as opposed to a person, and I think that illustrates the fact that the legislature intended for the Human Rights Act to apply to an employer as it has defined, greater than 12 employees within the state of West Virginia, as opposed to a supervisory employee such as Mr. Boucher. And so, Your Honor, with that, I realize that we are asking for a little bit of an extraordinary remedy in terms of reformulating the certified question, but this court has done that before, and we would ask that the court do that again, because this is an important issue, and it's an issue that will either in the future be back before this court on another certified question or before the Fourth Circuit on an appeal. And I would submit to this court that with due respect to the Fourth Circuit, this court is in the best position to make an interpretation of West Virginia law. Thank you, Your Honor.
Thank you. Counsel, you got about 2 minutes.
Your Honors, there is an absurdity in this case, but it's not the one argued by the respondents. The absurdity in this case is allowing definition of employer to be the tail wagging the dog, so to speak, in this case. The definition of employer is just that. It's the definition of employer. It's not a wholesale exemption from a multinational company like Under Armour from the statutory liability under the West Virginia Human Rights Act when it meets the plain definition of person irrespective of whether it also meets the definition of employer, which Ms. Pajak submits it does. But the absurdity is to allow the tail to wag the dog. It's a definition. We've cited in our reply brief to cases that say a definition is a definition, it's not a wholesale exemption. Your Honor, in addition, courts in Illinois in the Dana Tank case, Tennessee, the Emerson case, Kentucky, the Smith versus Lewis case, and in Massachusetts in the Chloride case, all with similar statutory constructions, have had no problem holding that an employer that does not meet the statutory definition of employer because it employs not the requisite number of employees, nonetheless can be held liable under the retaliation provisions of those similar statutes because the courts recognize that the legislatures purposefully made the liabilities under those different subsections apply to different entities. And so...
But isn't your argument, going back to what you said about letting Under Armour not be held liable because they're a large company, I mean, aren't you asking us, by bringing up that public policy argument, asking us to wander into the legislative role? The legislature defined employer. The way that it defined employer is kind of a unique definition, insofar as it's related to people actually in the state who are employed, and it doesn't bring in those who have many, many employees outside the state. Aren't you asking us to legislate a bit?
Your Honor, no, I'm not asking you to legislate at all. I'm asking you to read the plain language of the statute. And with regard to the last portion of your question, Your Honor, I'm asking you to take a hard look at the definition of employer where it says persons within the state, and to apply the last antecedent rule, and to determine that persons within the state means just that. It's the West Virginia citizens, and the purpose of the West Virginia Human Rights Act is stated to protect West Virginia citizens. But we submit that regardless, and it's not seeking, it's not even looking at who the employer is with regard to the statutory construction here. In fact, Your Honor, in cases like Hanlon versus Chambers, the courts had no problem saying that a person doing business as a chiropractic company and the chiropractic company are subject to liability under Section 9(7). Without regard, the court doesn't analyze the number of employees. It's just a matter of fact that a corporation, a legal entity, is a person under Section 9(7). And that's what the courts in these other jurisdictions have said without fail. The New Hampshire case cited by the respondents, in fact, said that the individual could be held liable. There's a dicta that says that it would be illogical to extend it, but that dicta wasn't well reasoned at all, and it certainly doesn't apply to Under Armour, the defendant in this case. It's dicta in a small portion of the opinion that no one has followed, whereas the opinions in Illinois, Tennessee, Kentucky, and Massachusetts have been followed in other cases. We cite some of those in our brief, and it's well-established law that the retaliation claim is special.
I think we understand your position. Thank you.
Thank you, Your Honor.
Case will be submitted.
The next case for oral argument is also being presented under Rule 20. James A. Moore Jr. versus ICG, Tygart Valley LLC, docket number 200028, and this case is on appeal from the Workers' Compensation Board of Review.
Good morning. Your Honors, may it please the Court, I'm Alan Carlin, and I'm here on behalf of James Jimmy Moore. And on November 14th, 2016, Mr. Moore was working in a coal mine in West Virginia. He had He had no reason to believe that he had any particular medical problems that prevented him from continuing the coal mine. He was driving his motor down into the mine, and as he was coming down into the mine, his brakes suddenly locked up, pushing him up, and his body went up and he hit his head against the canopy. Almost immediately thereafter, he had neck pain that continues to this day. It resulted in a fusion of certain bones in his cervical spine. And let me back up for a second here. Prior to this accident, he had no reason to believe that he had any problem with his cervical spine.
How old was he, counsel?
48 years old. He was approved under comp for sprain and strain, but he was not approved under comp for the cervical problems that he was having with his spine. The reason, and that's true despite the fact that I'm sorry, I'm having a bad morning. Despite the fact that the doctor who he saw for this was a doctor that was sought out by the company. And that doctor contended that he was not entitled to any further workers' comp for his cervical problems because
Mr. Carlin, is it your position that this caused a discrete new injury that as opposed to aggravating an old injury, that it was a discrete new injury and it should be compensable as a result of that?
Well, actually, and I think I should throw away my notes and I could probably do this better. What we're really contending is that the discrete new injury rule needs to be revisited. I think at least one of the justices here has previously indicated that it requires a revisit. And why is that? Well, here we have a situation where most of the facts are agreed upon. It's agreed upon. Let me just read you a couple isolated sections from the, sorry about this, from the depositions in the case. The doctor was Dr. Jin. That was his doctor. And Dr. Jin was a doctor that worked at the university, and when he had the injury, the company had their social worker escort him up to see this particular doctor. The doctor agreed with most of what we put on in the case. For example, I asked the doctor, is it true that Mr. Moore might have gone for at least many more years without any symptoms of cervical pain or radiculopathy? True. Answer, that's possible, yes. And you know that? True. Answer, yeah. So this is a guy who had no reason to believe that his career was on the line that day. I also asked him my point. I asked the Dr. Jin, my point is something happened on November 14th, 2016 to change the course of the cervical pain. Something changed. Something new happened. Did it not? That's my question. Answer, new symptoms happened, yes. And I asked, well, yeah, new symptoms happened because something must have happened in his neck. Answer from Dr. Jin, his neck being jarred, yes. Okay, and when we say he was jarred, he probably had some compression on the spinal cord. Correct. Excuse me, of the spine when he hit his head on canopy A, on the canopy. Answer, yes. On the shuttle car, true, yes. So the doctor who provided the basis for denying his claim for benefits arising out of his cervical problem agreed basically with most of what we were saying in the case. But she said she denied it, and the Office of Judges and the board relied on her because, in her opinion, as a medical doctor, there was not new pathology. She took the position that in order to have a discrete new injury, there absolutely had to be a new pathology. And I don't know that we know what that means, but that was the test.
What were the findings of the doctors with regard to the bulge and the I believe herniation? Were those pre-existing the jar in the car?
Of course.
Or were they?
I'm sorry, I didn't mean to interrupt you.
Or were they caused by?
I don't think anyone took a position on specifically that issue. But what we know happened is he had no cervical problems prior to the hitting his head on the canopy, and afterwards he did. And in other sections, which I didn't read to you, there's testimony. The testimony is that the pain that he was suffering, remember this other doctor did not question that he was suffering pain. She agreed he was suffering pain. She said it was due either to an irritation of a nerve that wasn't irritated before, or could have been an impingement of a nerve. But no one could say exactly what it was other than that it changed. We knew it changed because prior, undisputed, no problems with his neck. After accident, not disputed, no serious problems with his neck leading eventually to a fusion. Now, that's just creates two real reasons to revisit this issue. And the first real reason is that there is no really workable definition I think I've seen in the cases that have come out of a discrete new injury. I haven't seen a workable test. And what that does is it leaves it to the individual doctors who are testifying to come up with what they mean by a discrete new injury. And in this case, it's ridiculous to say that there wasn't a discrete new injury when we know that there was no pain before, pain after. The second reason I think it's important to revisit this case is that when you look at what happens, we're all aging. And I think we all know and can take judicial notice of the fact that as we age, we develop disc problems. It happens some to more and some to less. If you have a laboring job, to more. You're going to have more of those disc problems. So you're set up. You're working in the coal mines or wherever you happen to be working, and you're developing these disc problems, degenerative disc disease, but it's not affecting your ability to work. It's not affecting your job, and you're relying on your job to work and to feed your family and yourself. And then you get into an accident. Something happens like happened in this case. And that accident involves a pre-existing non-compensable situation, the degenerative disc disease, but it also involves the injury that occurred when he hit his head against the canopy. And what that does, the way it works right now, is it leaves it open to, and I don't want to diss employers because I think there are many good employers, but it leaves it open to those who may not be so good to say, fight the whole thing. Because if you have any degenerative disc disease in your neck and you jam your head up against a canopy, you can't get around the fact that there's this degenerative disc disease and you're denied benefits for it. And whoever thought, and I wonder if how much of you had thought about the fact before you saw this case, that what can happen is you can be denied benefits for something that clearly was caused by your work in the coal mines or wherever you happen to work. I'm not sure I'm making sense on that, but I hope I am.
Put another way, Mr. Carlin, are you essentially saying that a key fact in this case, among others, is that there were no symptoms of this disease that probably pre-existed the injury, but that the injury at work, which nobody disputes, brought forward or caused what ended up being symptoms of a disease that probably existed prior to the incident?
Yes, thank you.
Well, I didn't practice workers' comp on my prior life, so I always have to lay it out in the simplest terms.
And this is not, I'm sorry, go ahead. This is not so simple because there are layers of some of the questions that arise when you start looking at it. But for example, we don't need it. The definition of of compensable injury has been around for a long time, and going back to 1970, I think it was, when the Barnett case, which is cited, neither of the parties cited the Barnett case, but Gill, the leading case, relied in part on the Barnett case. And the notion there is that a compensable injury occurs when there's a personal injury incurred in the course of employment, and that injury resulted from employment, which you can see here. He certainly has a personal injury caused by the joinder of his pre-existing condition and the events when he hit his head in the canopy. It obviously occurred during the course of his employment, and more than that, it certainly was resulting from his employment. There's no way to separate those out.
Mr. Carlin, isn't there a significant difference between a pre-existing injury and a pre-existing condition?
I don't know that the cases have made that distinction, but
Well,
usually the way
and again, like my colleague, I practice very little and very minimally in the field of workers' compensation, so I'm learning as I go here. But the Gill case says a non-compensable pre-existing injury may not be added as a compensable component. But aren't you arguing that your guy didn't have an injury? He had a condition which is called degenerative disc disease that was not exhibiting any kind of adverse effect on his ability to work every day.
Yeah, that's true, but if I can fine-tune it, at least from my point of view,
Go right ahead.
If I can fine-tune it, he had a pre-existing disease, which was not compensable.
But that's a different from the Gill case talks about pre-existing injury. He had a disease, but it didn't affect him, right?
That's correct.
So, okay.
Well, I guess I'm not quite sure if we're disagreeing or agreeing, but I would just add.
I'll leave that up to me.
Well, I certainly will leave it up to you too. I don't have a choice. But what I was going to say was that a lot of these cases arise in the pre-existing non-compensable situation where there's a disc disease. That's where they arise. So you've got someone with a non-compensable underlying disc disease that on a particular day happens to literally smash against a new injury. Something happened. He certainly injured himself that day. And that's the way the cases come out. So or many of the cases, not all of them. So the danger is, as I've just articulated, that you create a situation where a lot of good working people who have perhaps had their cervical or other spine worn down more from their work, and then suddenly they get into an accident and they can't return to their work, or they have to miss a lot of their work and recover, and they're denied benefits. And I don't think most people think that that's the way it is, but that's the way it is under Gill. And then it leaves it up to the doctor to decide what's a discrete new injury. In this case, the doctor, there was some evidence of problems on the MRI, but not something distinct enough to grant benefits under her theory. She didn't see that as a pathology change. There's a couple other things that could be done too, and I understand that the concern here from the employer's point of view is that this will open up floodgates, but I don't think it would. If you adopt the Barnett test, and also I would also like to see you reaffirm what's blanking on the name of the case, the Manning Hall and another case that goes with it, which involves the situation where a miner or a worker is going along doing his work, and he suddenly has an injury he has a pre-existing injury, but the new injury Well, better, let me read it, because
Is that syllabus points 1 and 2 of Charlton?
Charlton, thank you.
No problem.
I've needed more help today than I ever needed before. Yes, the syllabus point in Charleston. In Charlton, a deceased workman who in the course of and resulting from employment receives an injury which aggravates or accelerates the disease to the extent of causing a disability sooner than would otherwise have occurred is entitled to compensation from Workers' Compensation Fund. What that means, as I understand it, is if you get a new injury and it doesn't totally disable you, if what it does is it makes it necessary for you to leave work sooner than you would otherwise have, as a case, which would affect Mr. Moore's case. That would also apply to Mr. Moore. And for those of you who are concerned about how broad this would extend, I would point out that in Gill, there was another section of Gill that didn't make it into a syllabus point, but that I think does make sense, unlike the discrete new injury. And that is, I'm going to read that one again, too. Where there is evidence of a pre-existing injury, the new claim that occurs when the pre-existing injury joins up with the injury of the day, when there is evidence of a pre-existing injury, the new claim will not be treated as compensable. In other words, we're going to deny this new claim unless it is directly attributable to a definite, isolated, and fortuitous occurrence, that is to say, from a definable incident resulting from his employment. Peeling back what that says, if I read it too fast, I think what it means is you can't come in and say, I woke up one morning and I had a bad cervical neck. That's pre-existing, non-compensable. But where it goes is that would be denied, and it would be denied because this would only cover cases where there was something like what happened to Jimmy Moore, that a specific occurrence has to kick it off. You can't just come in and say, well, I have a disc disease and I woke up the other morning and it was a problem and I want benefits. You'd have to have a situation, whereas in this case there truly is a close connection between the work environment and the pre-existing condition. Is that, I'm not so clear when I...
If you want to save a couple minutes for a rebuttal, you might want to...
Okay, well, I appreciate your attention to me and my lapse here. Thank you. I'll be back.
May it please the court, my name is Jeff Brannon. I represent ICG Tygart Valley in this case, the employer. There's no dispute about the facts in this case. This is actually a very simple case. For the most part, I don't disagree with a lot of the factual issues that Mr. Carlin raised here today. This court's standard of review set forth in statute requires you or permits you to reverse a decision of the board of review if it's has a constitutional violation or a statutory violation. We have neither of those here. If it is an erroneous statement of the law, which it's not in this case, or if there's a material misstatement of the facts. Now, this court's been very clear over the years that it will not perform a de novo review of the facts. In this case, the administrative law judge reviewed all of the facts. And again, this injury occurred in 2016. We're 6 years later now. There was one issue before the Office of Judges. That issue was whether a C5, C6 spondylosis with C6 radiculopathy was compensable. The claimant's own treating physician, while Mr. Carlin may not, has asserted that she was a company doctor. Dr. Jen is a fantastic occupational medicine physician who practiced at WVU for years. She has her own practice now. She treated Mr. Moore. I would submit that he couldn't have got a better treating physician. She concluded and she testified that His C5, C6 spondylosis with C6 radiculopathy was not related to this injury. Listen to the arguments from Mr. Carlin today. You would think that Mr. Moore hadn't received any benefits in this claim, that this claim wasn't held compensable. That's couldn't be farther from the truth. This claim was filed. He sustained an injury. The claim was filed, as Mr. Carlin noted. It was held compensable for a cervical injury. It was held compensable for a shoulder injury. Mr. Moore received benefits for those injuries. He received temporary total disability benefits. He received medical benefits. Again, the treatment by Dr. Jen. Eventually, it came to the point where his C5, C6 spondylosis, which is a degenerative condition, yes. It's a pre-existing condition, yes. It is a condition that all of the physicians in this case agree pre-existed the injury in this case. It came to the point where he needed to have a surgery, which he had. But that wasn't the issue before the Office of Judges. It wasn't the issue before the Board of Review. The issue was whether that specific diagnosis was compensable in this claim.
How is this case different from the Lemon case?
How is this case different from the Lemon case?
In the Lemon case, ultimately, the Supreme Court upheld a finding that surgery and injury for a ruptured disc was compensable. How is that different?
And Your Honor, you mentioned that earlier. There's not a ruptured disc in this case.
There's a bulging disc.
There's a C5, C6 spondylosis, which by definition is a degenerative condition with radiculopathy. And as Mr. Carlin asked the court to take judicial notice of, we all have that as we get older. Okay, that's not directly related to the injury in this case, and it's different from Lemon because he didn't have the herniated disc. If you have a pre-existing condition in your neck and you had this injury and it herniated a disc, that's a discrete new injury. That's a discrete new diagnosis code that the doctor can say, here's a herniated disc. We need to treat this. That didn't happen in this case. They were requesting that this pre-existing, non-compensable degenerative condition be added to this case, and the Office of Judges and Board of Review correctly determined that that was not compensable. Now, in the briefs, counsel, Mr. Moore is requesting that radiculopathy and radicular symptoms be added. Okay, the Office of Judges didn't preclude that. The Board of Review didn't preclude that. As we sit here today, Mr. Moore can request from the claims administrator to have any other condition he wants added to this claim. The only issue before the Office of Judges and the Board of Review was this C5, C6 spondylosis, which everyone agrees was pre-existing and not caused by this injury. Now, it may have been aggravated, and to the extent that it was aggravated, he received benefits. He received additional temporary total. He received medical treatment. He received benefits for that condition to the extent that it was aggravated by the injury. This injury is compensable, and it is a cervical sprain strain. It's not like the neck was denied, and it's not like he cannot request these benefits from the claims administrator, which would be appropriate under the workers' compensation statute, and that's the authority delegated to the claims administrator, is for the claimant to request, or the physician to request those conditions be added and it be ruled on, and then once that's ruled on, it would be properly before this court. Another issue with Lemon is that this court performed a de novo review, reversed a Board of Review decision which had affirmed an Office of Judges decision, denying the claim. On a petition for review, this court said, we can't do that. That's inconsistent with our standard review, and I would submit in this case, reversing a considered decision by the Office of Judges and the Board of Review is inconsistent with your own standard review.
Except that, would you agree that there is significantly different opinions as to what constitutes a discrete new injury, especially in light of the case where there is a pre-existing medical condition that is otherwise not symptomatic?
I don't agree with that. I don't agree with that. In trying to think of an example, off the top of my head right now. For example, if I were to trip and fall on my way out the courtroom today and injure my knee, and they go and I have an MRI, I have a torn meniscus in my knee. I've had it for 15, 20 years now. That's a pre-existing condition. Would that be compensable because I injured myself walking out of the courtroom? Or would the aggravation of that be treated and I get benefits for it, but they're not going to, I shouldn't have that surgery paid for, which I needed before? And Dr. Jen, as Mr. Carlin said, testified that yes, eventually he was going to need the surgery that he's eventually had for this pre-existing condition. Was it hastened? It may have been, but we don't know that. As we talk here today, another issue is when you're talking about the Gill decision and the use of the word pre-existing injury. I have to agree, I don't necessarily know what that means. I think what the court meant in that was a pre-existing condition, not an injury. And those are clearly different. In this case, we have a disease, as Mr. Carlin said, that the claimant suffered from before. If we apply just simply the 2341 standard, you have to have an injury in the course of and resulting from your employment. Was the C5, C6 spondylosis that he suffered from before the date of injury an injury which occurred on that date? No. Everyone agrees. All of the physicians agree in this case that it pre-existed. So it can't fall under that 2341 definition. Under Jordan and Gill, these pre-existing conditions cannot be added as compensable. If, as I said earlier, if in fact he had had a herniated disc that was acute, that would absolutely be compensable. But the aggravation of this pre-existing condition doesn't fit the definition of an injury under workers' compensation.
So let me give you a chance to respond to Mr. Carlin's argument that we should take a look at syllabus points 1 and 2 of Charlton. What's your response to that?
Unfortunately, Your Honor, I do not have those before me, and I don't know them specifically off the top of my head.
Not a problem.
I don't think that they're
because the court is fully aware of the circumstances of you standing at this podium today. So I'm gonna.
I don't think it's inconsistent, Your Honor. I don't think that that what was described and I heard is inconsistent with what I'm arguing here today. Over the years, the court has, I won't say drawn bright lines, and there shouldn't be bright lines. Workers' comp is a creature of statute. The legislature defines what an injury is, what benefits the claimant's entitled to. And we try to interpret that in a manner that is fair and equitable. The case law has been consistent going all the way back to Jordan that aggravation is not compensable. The aggravation of that pre-existing condition is not compensable. I likened it the other day to the Aware case where you have an idiopathic fall. Somebody has syncope and falls off of a ladder. Well, the syncope isn't going to be compensable. That's what caused the injury. But the injuries they have when they hit the floor, a broken leg, a broken arm, those are going to be compensable. But the syncope's not, or syncope, however you'd like to pronounce it. So I don't think it's necessarily inconsistent. I think that, and I apologize, but while the syllabus point in Gill, I think, may have been inartfully drafted, I think it is consistent with all of our prior case law. I don't think it was anything new. I think that the court in Gill could have simply just restated the Jordan syllabus points. There's nothing new here today.
Counsel, hypothetically, if instead of the injury he suffered, this particular worker had an unusually thin skull, when he hit the bump, he hit his head and suffered an injury that would exceed in severity that he would have suffered had he not had a thin skull. Would that be a compensable injury?
For example, a fractured vertebrae because he had osteoporosis, or a fractured skull for the same condition? Is that the hypothetical? Literally using thin skull. I would say yes, because you're going to have that diagnosis code of a fracture.
Even though he would not have suffered that fracture, but for the abnormally thin skull.
Yes.
You're saying that would be compensable, but on the other hand, if instead of a thin skull, it is the process of aging resulted in an asymptomatic condition, then it's not compensable.
It's a disease. It's a disease that we all suffer from over time.
If you have a congenital defect in your skull, that's not a disease, and therefore it is compensable. But if it's a...
Your Honor, the congenital condition is never going to be compensable. The fracture will be compensable, okay? But the congenital condition cannot be added to the claim. Just like here, the degenerative condition can't be added, but if there was a fractured vertebrae or a herniated disc, yes.
Well, the congenital condition made the person more susceptible to a severe injury. Would the severity, would the fact that the injury was more severe because of the congenital condition limit the amount of compensation benefits he could receive?
No, Your Honor. No, Your Honor. No. Again, the disease itself won't be compensable. The injury, the fracture, would be compensable, and the injured worker would be entitled to temporary total disability benefits, medical benefits, all of the benefits that are normally associated with workers' compensation. They would be entitled to that. Again, and that's not to say that a disease cannot be compensable, because clearly it can under 2341. It just happens that we're not here on a disease claim, we're on an injury claim. The statute requires 6 factors to be met before a disease can be added, and I would submit that those 6 factors aren't met here to add the C5, C6 spondylosis with radiculopathy, C6 radiculopathy that was requested. Again, if there is another condition that Mr. Moore needs to have added to this claim, his treating physician can ask for it. His attorney can ask for it. And it will be ruled upon by the claims administrator, and if there is sufficient evidence that that is related, then it will be added. If there's not, it'll be denied, and he will be given the opportunity to litigate the issue before the Office of Judges and the Board of Review. Again, as I stated to begin with, that's not the issue here today. The issue here today is whether the Office of Judges and Board of Review were incorrect in denying the inclusion of the C5, C6 radiculopathy as compensable. Nothing else is precluded. That is the only issue that they addressed. Thank you for your time today, Your Honor.
All right, thank you. Mr. Carlin, you got about 3 minutes.
3 minutes? Oh, gosh. I'll try. First of all, whether there was an erroneous conclusion of law, so the court does can address these issues. The erroneous conclusion of law was the adoption of Dr. Jin's theory that you can't get a discrete new injury unless you have a change in pathology, and that's there is a pain there what shouldn't that's too harsh a requirement. But even if you do adopt that and you like that for some reason, there still was a change. There was an injury here. The injury was not the pre-existing injury. The injury was when his head hit the canopy, something happened inside. Just it doesn't show up yet on an MRI, or it may be precursor on the MRI. And that was, Dr. Jin said that this was caused by either an irritation or an impingement of a nerve. We know that. That's what happened. That's why he didn't hurt one day and he did hurt the next day. And so the court can reach and address that even if it keeps the new injuries requirement. Dr. Jin admitted that she is often asked by employers or insurance companies, I forget which, to do IMEs, but she's never asked by lawyers for the workers. And I think that speaks volumes. The spondylosis that he talked about, of course it's a pre-existing condition. If it weren't a pre-existing condition, we wouldn't need to go through all this analysis. The issue is not whether spondylosis is or is not. It's what happens when you hit your head against a canopy and it does something to shake up the way your nerves are inside, so that now you have pain that you didn't have before, and that continues to get worse until you need a fusion. That's the change that happened to him on that day. To say that it was not a distinct new injury just because it doesn't show up yet on an MRI, I think is a mistake. And it clearly was an injury incurred during the course of employment. Counsel made it sound like all we need to do is file new papers. That's not true. He was denied, he doesn't get to choose what the doctor puts down on the paper, but the doctor put down spondylosis with radiculopathy. Now, the spondylosis we know is non-compensable, because if it were compensable, it wouldn't be an issue. So, of course, spondylosis is non-compensable. When he hit his head, though, on the canopy, that created something new. Maybe whether it's a new injury or not depends on what definition you give to it. But it shouldn't matter. It shouldn't be what the doctor chooses to call a new pathology when the doctor has admitted that something new did happen, but it's just new symptoms, not new pathology. That shouldn't, a person's right to benefits shouldn't be based upon that kind of definition. Let me just take a quick look at my notes. We can't go back and just file again. Dr. France, who did the surgery, and a leading doctor at WVU, called it what he called it, spondylosis with radiculopathy. Dr. Vaglienti, also from WVU, called it the same thing. And even Dr. Jin, when she put these codes that we've talked about, those were originally billing codes. And there aren't codes that fit every definition. But it's interesting that Dr. Jin, when she put the codes in for Mr. Moore, she put in a code of, 54.12, which is a code for radiculopathy. She put it in on my client's medical records. And so that is a good code and should have been granted. And thank you for your attention and your support.
Thank you. The matter will be submitted.
The next case for oral argument is also being argued under Rule 20, In Re KS, docket number 210180, an appeal from the Circuit Court of Monongalia County, West Virginia.
Quick, counsel.
Thank you. Okay. I'm waiting for, am I waiting for Justice Armistead to return, or?
No, go ahead.
Oh, okay. Well, please the court. My name is Todd Phillips. I represent GH. It's the father of KS. And GH petitions the court to reverse an order from the Circuit Court of Monongalia County denying his motion to retroactively modify and discharge a child support order owed to the respondent today, individual whose parental rights were involuntarily terminated. This came from an abuse and neglect case. The department filed a petition alleging that the respondent SS abused or neglected KS. This was filed in February of 2019. Pursuant to that, GH was granted sole custody of his daughter. Prior to that time, there had been no court order concerning the child's care and custody. She was 9 years old at the time, and there had been no order concerning the care and custody. There was a child support order. At the time GH was given sole custody of his daughter, there was an arrearage for the child support of over $9,000 in principal and over $5,000 in interest. Now, in the case,
So let me go back. When custody changed, did the circuit court order the mother to pay child support?
no, not until the court ordered support owed by the father suspended as of February 1st, 2019. The mother was not ordered to pay support until January of 2021 in post-termination proceedings.
But wasn't the circuit court required to do that by statute?
Yeah, they didn't. I think it was presented to the fathers, and there were 3 fathers on the case. It was presented to them, you might get $50 each at most, and they said, we don't think we'll even see that. And so none of the fathers nor the department pursued support.
There was a specific date, however, where the court did suspend your client's obligation to pay child support.
Yes, that was February 1st, 2019.
And so since that date, he has not accumulated any arrears.
Correct.
Okay.
So, Mr. Phillips, is it safe to say when the mother had the child, your client basically was paying at most sporadically his court-ordered
correct.
child support?
Correct.
So he didn't pay when she had the child. Now that he has the child, he wants her to pay, but he doesn't want to pay what he owes her. And your position is it's because it would be an undue hardship on the child.
Yes, the support is the right of the child. It's, as court has said, it's exclusively for the child's economic benefit, and it's his position that there is no way for the child to benefit if he is forced to pay money to an individual without parental rights, having been involuntarily terminated. It creates a situation where the respondent is unable, by law, is prohibited from directing the child's care, protecting the child, being involved, but would be receiving funds specifically designed for the child's care and well-being.
How much was he ordered to pay?
It was $248 a month, and it accumulated over the years. The parents lived together on and off. It was never modified when they lived together, and it continued to accumulate.
Is there any evidence in the record that would indicate whether or not, had this money been available, that the mother might not have gotten into the condition that she ended up in?
Yeah, I believe I addressed that in the motion. There were no home conditions or alleged no allegations that the child wasn't provided for. And that, I think I cite the department reports in that it was solely a case of the mother using methamphetamine when caring for 3 children.
Well, let me ask you this question so that I understand exactly how this process works. At some point in time, a child support order was issued in this case.
Yes.
And to issue a child support order, there has to be a calculation of the ability of both parties to pay.
Yes.
And so there would have been a calculated amount that the mother would have owed, and there would have been a calculated amount that the father would have owed.
Yes.
And because the mother had custody, she didn't actually have to pay herself, right?
Right.
And so what we're saying here is over the course of this period of time, she not only bore her personal obligation, but she also bore his personal obligation without help. Is that right?
I can see where you're going with that.
I'm pretty direct.
I don't have the documents from the original proceedings. I know it was a case brought by the Bureau for Child Support Enforcement, so I assume it was the mother was receiving benefits, so they were required by law to file. And at 248, I know that's the calculation when both parents are attributed minimum wage at 40 hours a week.
So you're not asking to be forgiven of what the support from the state was, is that my understanding?
That's correct, Your Honor.
You're just asking to be discharged from what he owed the mother herself?
Correct. Yeah,
but you want her to pay you now that...
There is a support order now starting in January of 2021. And
how much is he ordered to pay monthly for the arrearage?
Well, the support was $248 a month. That has not been recalculated.
How much is her support per month?
Her support now, I believe, is $75 a month. And
can it just both be paid or attributed to her and to be Bureau of Child Support with the offset?
I think something like that could be worked out. Also, I presented to the court, giving the court the option of money for a college fund or something else to see that the child gets the benefit of the support. There would be, I know the guardian ad litem brought up the possibility of offset, but the court ruled that it couldn't really consider any of that because it relied on the Goff hearing, finding that child support can be retroactively modified only in the case of fraud or similar conduct at the time the order is obtained. And
how much money, if Bureau of Child Support Enforcement brought the action to establish child support, which is their obligation if the Department of Health and Human Resources is supporting the mother and the child. That we understand that, right?
Yes.
How much is the state entitled to recover of the $9,000 and the interest? How much is the state entitled to recover from?
The state arrearage is separate, and I believe Respondents' Counsel calculated that at something around $10,000, 10 to 12.
Okay, so we are in a position where the state's amount is out there, the mom's amount is out there.
Yeah.
And what you're trying to get rid of is mom.
That's correct, Your Honor.
And I think he asked that question already, but I understand it now. Thank
Yeah,
you.
that's the, that's all, yeah, it only concerns the arrearage owed to the mother respondent. And as I was going to say, the court adopted the mother's argument that it was black letter law. I think the respondent repeats that in briefs filed with this court, as does the state. And Goff is not immutable. It's not black letter law. This court has said that it is a general law. And this court has allowed retroactive modification in cases where the child benefits or where there's no detriment to the child and equitable principles are advanced. Those cases are very disparate, fact-specific. This is the only case, I think, with a fact pattern that can and will be repeated, with a custodial parent owing an arrearage to an individual whose rights have been terminated. So I think this, just looking at the best interest of the child, I think retroactive modification and discharge is appropriate in this case, is consistent with the previous decisions, and I think even more deserving. As we get into, I think it violates the policies and purposes of child support when an individual has whose right to care for the child has been taken away by court action can receive funds that are specifically identified to benefit the child. And going back to how this is in a, I think can be seen in a different type of case. The Goff decision, every case citing that, and I listed them in a footnote in brief, those are all cases concerning support owed to a custodial parent. Almost all of them, the primary custodial parent. In other cases, the facts were a little different with changes in custody, or maybe the custodial parent of one of 4 children or stuff like that. But it's all, that rule's applicable when there's money owed to a custodial parent. I think we've gotten completely out of this when it's an individual who's not a parent, whose parental rights were terminated. And I think, we have to have a resolution that sees that KS receives the benefit of support. She's entitled to that. The support is there to benefit her. And I think, Your Honors, it's sometimes silence speaks very loudly. And in this case, in the underlying action, the respondent, the guardian ad litem, the state was silent there, but they didn't. No one argued that denying Mr. GH's motion was in the best interest of the child. In the briefs filed with this court by the state, by the respondent, by the guardian ad litem. So they do not argue that denying his appeal, retroactively modifying and discharging the support, denying him that, they don't argue that that's best for the child. And they can't. It's inconceivable that an individual who has no rights to the child can collect money from the child's sole custodial parent when said money is there to benefit the child. And I think the fact that no one advancing a position against GH can claim that it's in the best interest of the child intended to benefit says a lot. And the supports for her benefit, the abuse and neglect proceedings were for her benefit. Asking the court to, in summation, the retroactive modification and discharge is consistent with the previous rulings of the court. It's even more deserving and is in a, I believe, in a separate fact-specific category when it's not a custodial parent but an individual whose rights were terminated. And it's what would be best for the child, and ask the court today to reverse the circuit court order and retroactively and modify and modify and discharge the child support order in that case. Thank you.
Thank you.
And do I have, how much time would I have?
You've got about 5 minutes.
Oh, 5 minutes, okay, great, thank you.
Counsel? My understanding is that counsel for the department and counsel for the respondent SS are going to split the time.
Okay, thank you. Good morning, Justices. My name is Cheryl Warman. I'm an attorney from Morgantown, and I represent the respondent SS, who is the mother of the child KS. And first of all, I would like to say that I do believe that the issue in this case is controlled by black letter law. It's been longstanding in the decisions of this court that retroactive modification of child support is not possible. It can only be done prospectively. Now, this case has a bit of a different factual scenario in that here we are dealing with a mother whose parental rights were terminated. That is correct, that the court has not dealt with this specific fact pattern in terms of retroactive modifications. However, I see no legitimate reason, either from a best interest standpoint or from an equity standpoint, why the long-standing decisions of this court should not also apply in this factual scenario.
Counsel, let me ask you a question. Your client has a decretal judgment against the petitioner in this case, right?
Yes.
And that decretal judgment was issued by a family court?
Yes.
Correct. Now, did the family court have jurisdiction to enter that decretal judgment? Because at the time the decretal judgment was entered, the abuse and neglect case, as I understand it, was ongoing.
That is true.
So how under Rule 6 did the family court have jurisdiction to enter the decretal judgment?
Well, I was not involved in that.
I'm not accusing you. I'm not accusing you.
I believe that the court did have the family court did have jurisdiction because it was for past support. It was not for ongoing support that was accruing after the abuse and neglect case started.
My understanding of Rule 6 is it's pretty cut and dried. If there's an abuse and neglect case, anything dealing with that case goes straight to circuit court. You agree?
Pretty much, but here's the way I look at it. Mr. Phillips, on behalf of his client, has not contested the fact that the money is owed, okay? He does not contest the fact of the amount of the money owed. So what he is asking for is for it to be discharged. He's not saying that it's not a legitimate debt. He's saying that he just shouldn't have to pay it. So accrued installments of child support stand as decretal judgments regardless of whether a court ever explicitly enters a decretal judgment or not. So I don't see it as being particularly relevant to the overall picture that the family court is the entity that issued this decretal judgment. As Mr. Phillips pointed out, that proceeding was an enforcement matter brought by the Bureau of Child Support Proceedings and was not instituted by the mother.
Counsel, so let me just make sure, timing-wise, that I get straight, following up on the Chief Justice's question. So when the initial order directing the child support was entered, the original order, there was no ongoing abuse and neglect case at that time?
The original child support order back years ago?
The one that the petitioner has not paid the support for.
Oh, that was going on. That accrued for a period of years prior to the institution.
What I'm saying, the original order that was entered was not entered during a time when there was any abuse and neglect case.
Oh, correct. Correct.
So
absolutely.
Just make sure I understand what you're saying. So even if there wasn't a subsequent order that enforced that and said you still have to pay that, you're saying, if I'm correct, that even if that order had or had not been entered, it was still the original order that directed. Is that what you're arguing?
Yes.
Okay.
Yes.
Okay.
Now, I find it somewhat interesting and hypocritical, as a matter of fact, for this father to come into court and argue issues like best interests of the child and equitable principles when basically through the course of almost 10 years, he was what I will term a deadbeat dad. And now all of a sudden he becomes concerned about the best interests of the child. Where was his concern about the best interests of the child when he was failing to pay $248 a month over a period of about 10 years before the abuse and neglect proceedings started? He's asking to be relieved of this debt that he owes to the mother. Now, and Mr. Phillips has argued in support of his position. He has cited a case, the Costello case, which he referred to in his brief, and I mentioned it in mine as well. And that case involved a child support that was owed to a mother, and then the mother died with an accrued arrearage owed to her by her ex-husband. And in Syllabus Point, that's a West Virginia Supreme Court case from 1996, and the syllabus point, single syllabus point in that case stated, it is presumed that when the obliger fails to make his or her child support payments as ordered, the obligee assumed that additional burden in such a manner so as to protect the welfare of the child. And therefore, in the event that the obligee dies, his or her estate is entitled to recoup from the obligated party the child support arrearage which accrued prior to the death of the obligee. Then it goes on to say, this presumption may be rebutted if the court makes written findings on the record that there is clear, cogent, and convincing evidence that the welfare of the child for whom the child support payments were ordered was adversely affected or would be adversely affected if the child support arrearage is given to the obligee's estate.
Ms. Horman, can I ask you a question?
Yes.
And is it ever proper for the court to go back and look at the circumstances, and was that done here? For instance, if the father was making $600 a month total income, and he's having to pay out $250 of that to the mother for the past due accrued amounts, was that done? Was there ever any kind of an analysis of financial records put into place so that the judge could see and say, wait a second here, this would not be good. He doesn't even make enough money to pay the electric bill if we give this money over, and so therefore the child's going to be cold or not eat unless they get SNAP benefits.
You mean, was that analysis done at some point in the past,
No,
or in the context of the abuse and neglect case?
In the context of this order that he's asking to have set aside. Did the judge look at that at all?
There were some proffers made by the father's attorney, but there was, at the hearing that we had on this, it was not an evidentiary hearing.
So how could there be a best interest finding made if we don't know what the circumstances are?
That is correct. I mean, this was an argument solely based upon the briefs that Mr. Phillips and I presented, and there was no testimony taken from either the mother or the father. It was basically a ruling by the court that you can't retroactively modify child support, an accrued arrearage that's been reduced to a
when the
decretal
motion was
judgment.
made to discharge that past obligation, was there anything set forth? And here's the basis that I'm asking this to be done. That I make $600 a month, my monthly expenses are $597, and to take $240 of it away would not allow me to even provide food for my child.
That Mr. Phillips made that argument, but there was no testimony taken. There was nothing admitted into evidence to support that. It was more of a general argument that it would be a hard economic hardship on him. But even so, I mean, if at any point in the past, if GH, the father, had determined that he could not afford to pay $248 a month, the obligation was on him to go back to court and seek to modify that, and he had a right to do that at any point during the many years that this arrearage accumulated, but he did not take advantage of the opportunity to do that. So,
You're about 10 minutes in, so I don't know how.
okay,
how you
well,
guys-
I will sum up. I just think that there isn't any law that supports doing what Mr. Phillips has asked to do, and I think it opens up a can of worms in terms of a floodgate of litigation from other obligors that owe child support, huge child support arrearages, which often happens, in my experience, in child abuse and neglect cases. And I can foresee a number of factual scenarios where this could come up. What if there's a disposition 5? I mean, what if my client had received a disposition 5 instead of a termination, which would give her the opportunity to go back to court at some point in the future and seek a restoration of some sort of custodial, possibilities with her child. And then the debt is extinguished, then that money could not be available for the benefit of the child. And furthermore, according to Costello, if you use Costello analysis in this case, there's a presumption that the mother made up the difference from what was lacking due to the father's non-payment. She had to make that up on her own to make sure that the child was taken care of. And that's why the money, should be paid to her, because there's more. Child support is not just a handout money to a child. It's to take care of food, clothing, a roof over her head, utilities, and all that, which the mother had to pay, and she had to figure out a way to do that during all those years when the father was not making the support payments. Thank you.
You got about 8 minutes, Counsel.
Okay, thank you. May it please the court, Lena Zgoda, Assistant Attorney General representing the DHHR today. The department agrees that this court has provided some exceptions to the black letter law, which prohibits retroactive modification of child support, but disagrees that any of those exceptions apply in this case. The Docket case set the rule against retroactive modification with child support, but made an exception only if there's fraud in the procurement of the child support award. While there have been some other cases subsequent to that which have allowed some exceptions to that rule, those have been very, very narrowly crafted and applied in only limited circumstances. For example, the Subco case where we dealt with de facto change of custody, the Rebecca C. case where there was an unforeseen medical expense for the child and they went back and retroactively modified. But none of those exceptions could be termed general, and I think the key to this case is this. Petitioner asked this court to make an exception in this particular case for a very general best interest standard. He's not making a specific argument about how him having to pay back this child support arrearage is going to be detrimental to the child. He's just saying, hey, if I have more disposable income, it's got to be better for this child. And that's the problem with his argument, I think. In this particular case, and I think it was Justice Hutchinson asked some questions about what evidence, or perhaps Justice Most asked some questions about what evidence was presented, and that is key here. Respondent Mother's Counsel indicated that there was no testimony presented, but I see nothing of record that shows that that was prohibited by the court in this case. It was petitioner's motion. Petitioner chose to file an affidavit which set forth some very, very non-distinct, generalized statements about income and why he'd failed to pay child support in the past. And that's all the record shows. It doesn't show that he elected to place his client under oath and have him questioned and present testimony about specific characteristics of his income, his household. what his expenses were. None of that was presented. So all the circuit court was left with in this particular case to try to carve an exception out for this case was very, very generalized information. And so that's the problem with petitioner's argument. Had more specific information been presented, the case may have gone differently. But because he failed to present any evidence which would show that this child was specifically suffered detriment were he to repay this child support arrearage, the circuit court denied his motion appropriately, and this court should also do that. The department's concern, as the court's aware, the department is being repaid the amount that was due to the BCSE in this case. It is separate from the arrears which is owed to the respondent mother. However, we have a very tenuous circumstance here. Were this court to go down that slippery slope of allowing this door to be opened wider than it is at this point, we could be looking at CPS referrals that were made falsely for parents to discharge child support arrears. We could be looking at opening a door for maybe situations where we don't have abuse and neglect proceedings, but we have a custodial parent who's seeking to change custody and decides that a CPS referral or a petition saying that this parent has committed some bad act. Because really, if we look at petitioner's argument in detail, I don't think he mentioned it a whole bunch in his oral argument, but his brief certainly does. He's asking this court to look at the respondent mother as a bad actor. He's asking this court to make a rule that because her parental rights were terminated, that she should not be repaid the child support arrearage. And that's really a slippery slope for this court to go down. And the department is very concerned about the ramifications for CPS, for BCSE in a situation like this.
Procedurally, counsel, you are being repaid, and tell me if I'm wrong about how this. The child currently is entitled to receive some benefits from the department. And because she is now in the custody of her dad, those benefits, or part of those benefits, are being withheld and counted against the arrearage. Is that how it's working for the department to get their money back?
I'm not sure that the father, there's no indicator of record that the father has made any application for benefits. Okay. The department worker encouraged him to do so from the very beginning of the case. However, at the time of the dispositional hearing, there's no evidence that he had actually done that. And I think even the circuit court may have made him aware or reminded him that that he had that opportunity.
Okay, so if the department's getting anything back, he is actually paying it back.
That would have to be the case.
Okay, thank you.
Yes.
So back to that point, Ms. Niscott.
Yes.
You're saying he has not made application. Evidently, the mother did, because he wasn't paying, so she was receiving benefits that now he's going to have to pay back to the state, and he doesn't disagree with that.
That is correct.
But you're saying he hasn't applied for benefits, but he comes in and he's saying, because I don't have any income, that I can't take care of my child if you force me to pay the accrued debt that I owed. However, I'm not going to take any affirmative action to try to acquire benefits that the child would be entitled to under the law, such as SNAP, whatever, medical card, or whatever other assistance is available out there.
That's absolutely correct. And I will say that I don't have any knowledge of whether or not he's applied recently, but I can say that as of the time of disposition and in some subsequent hearings, it didn't appear that he had applied for any of those benefits. In addition, it's important to note that he didn't he didn't move the court to set child support. And while I understand there are other safeties in place, there are other actors, the guardian ad litem and other folks who, in the court itself, who may have encouraged him to do that. He didn't make any overt attempt to collect support from her at all, and the record bears out that the department worker who worked this case advised him at the very beginning, and I believe the guardian ad litem as well, that that was something that was available to him, that he needed to make an action and apply for that or make a motion to do that because the department did not have custody of these children. They went straight to the parents. But the department worker advised him that that was available to him and to all the other parents in this case who took, there were 3 children total. We're just dealing with 1 right now. But they were all advised of that, and he failed to do that. Which brings me back to another point, which is that...
Was that his job or the court's job to do that?
Well, I think he needs to take some responsibility to bring that before the court and bring that to the court's attention.
But going back to my question.
I think that the court did do it, but I would agree with you. It would have been nice had the court made that overt effort earlier. I'm not sure if it was because the court didn't realize it or the court was unaware or not thinking about the fact that the department didn't have custody of the children, because that is an unusual circumstance. So I would give deference to the court on that issue because it doesn't happen every day.
But the court did it at disposition?
Well, actually, it wasn't at disposition. It was during petitioner's motion hearing that the court looked at the issue and in the end advised him, go make a motion. And that's going to the point, the other point that I have is that if petitioner had made that motion, and this is what the circuit court advised him, if you had made that motion from the very beginning, we could have counted the money that she would have owed to you, which was incidentally $248 because it's based upon minimum wage on both sides. So it would have been $248 a month, which was what his support would have been or was, that he failed to pay, and it would have canceled out. Now, there may have been some interest charges there, but it would have effectively canceled out the arrears, and it couldn't still be done because he went after disposition, sought that child support order, got it, it's $248, and so were there to be an offset, which the circuit court actually suggested at the motion hearing, then that could possibly eliminate the problem, at least of repayment of the arrears to mother.
Offset.
Yes, an offset. Pretty much 100%, except for interest in this case. So the bottom line, I think, legally is that the Goff case set that bright line rule. The Goff case was appropriate. It should be a hard and fast rule because we need to make a hard and fast rule when we're dealing with child support and with folks who could make allegations against each other. So we need a bright line rule. It's there, it's in place. There are some exceptions. All of those exceptions are appropriate, and they're appropriately narrow, very, very narrow exceptions, and we should keep it that way. So let's keep those narrow exceptions in place. Had petitioner presented the evidence that he needed to regarding best interest specifically, this could have gone differently, but he didn't, and the circuit court made the right decision.
Thank you. Counsel, you got about 4 minutes. I'm sorry, I do that all the time. You need a break. Madam Guardian, you have about 5 minutes.
May it please the court, my name is Stephanie Nethkin, and I was appointed as guardian ad litem in this case. As stated by the respondent mother's counsel and the counsel for the state, it was actually my suggestion to do the offset because it made sense to me that for all of these years that the father did not pay child support, the mother was picking up that burden. So she was having to basically pay for the support for the child, of which a benefit of 2 parents would benefit the child. I believe that he is not disputing that he owes that money to her, but just because the parental rights were terminated, that he somehow does not owe this money to her, and that it should be discharged. However, with the since there was no testimony or any evidence put on record about how this would affect the child in this situation, I believe that the court made the proper decision in not discharging the arrearages because it was essentially paying back the mother for his portion of the support of the child. Now, I do believe that with the offset, when the mother is required to pay the child support to the father, if the court would have retrospectively put that in place when the father took custody, as the state council has provided, it would have offset a good portion of that for the 248.
Could that
And
still be done?
what
Could
was
that
it?
still be done?
I believe that it could still be done.
Back to the time that he took custody of the child.
I believe that it could be done. And so I think if this court would remand back to circuit court, that could be the suggestion that this court makes, because once he retained custody in February of 2019, he was caring for that child. Now, he didn't ask for child support at that time because the mother was not working. She was working on her sobriety. She was in and out of rehab, and he was fine with supporting the child to give her that opportunity to succeed in her improvement period. But I think that the court could go back, now that, you know, the rights have been terminated, to go back to that point when he did receive custody, and apply the child support calculation at that point. So in this instance, I do believe that the court was correct in not discharging it completely, but I would agree that it could go back, and then that would offset whatever he did owe. But that's also fixing the problem that he did owe mom while she was basically doing double duty and paying his side of the child support. So I believe that it's in the best interest of the child to do the offset, because that utilizes his income that he has at his disposal now, and also basically pays back mom what she had utilized during the time that she had custody of the child. So I believe it is in the best interest of the child to do it that way, because as Mr. Phillips said, the child support is for the benefit of the child. However, as Ms. Warman had stated, the respondent mother had taken care of that child for, you know, food, shelter, clothing, anything that the child would need at that point in time. So I understand Mr. Phillips' argument that we could put this in a trust or a college fund for the child. However, it's not solely for that issue. Child support is used to support the life of the child and what the child may need. Thank you.
Right, thank you very much. Now you've got 4.
Quickly, Your Honors. First, Ms. Warman was correct about the hearing. It was presented to us as legal arguments. I had 13 days to brief it, and we were, Ms. Warman and I both under the understanding it was not an evidentiary hearing, and I was able to attach a short affidavit to it showing the history of the parties living on and off, Mr. GH providing most of the providing all the support during those periods that they were together.
But is that enough, Mr. Phillips, for the court to say, okay, I accept that? You're saying it's going to be a hardship, I accept it, I don't need to know how much money the parties make, I don't need to know anything?
In the case where money's owed to someone who's not a custodial parent, I think that is enough, though the court might differ. In general, yeah, that's the second relief requested would be a remand to determine what is going to be in the child's best interest.
Why didn't he do it in the first place? That was his burden.
What's that?
We said it would have been your client's burden to present this in the first place, wouldn't it?
We presented what the law was, which we said that it permitted modification. The court, relying on Goff, said there was no modification permitted except in fraud. So we would like the court to rule that that is incorrect, that this court has never called, I keep hearing black letter law, this court has never called golf black letter law. It has called it a general rule.
Okay, what about the issue Ms. Warman raises that says he hasn't even applied for any benefits for the child? Has he?
I'm not sure about benefits, and he did file for support that he was awarded in January of last year, and then the mother had that amount reduced.
Why would he not have applied for SNAP benefits or things of that nature? He would have been qualified if what you're saying is true with other kind of benefits through the State Department, perhaps, would he not?
Yeah. I imagine he could have been eligible at some point for some benefits. I don't know if he did it or when. We were not in, those were not topics I was discussing with
Well, if he didn't apply for that over this past year, that federal act during the pandemic increased SNAP benefits to $200 and some or $300 and some a month. I don't even know what the amount is, but that would have been more than his payment would have been.
Yeah, and he might have done that, Your Honor. I don't know. I know he works hard and is able to provide a good, loving home. Just quickly, a couple other things. There's no floodgate. That's a scare that's not going to happen. This, as I said, the facts on this are facts that are unlike the other cases, are likely to be repeated, and they are very narrow. It's custodial parent, child intended to support, owing arrearage to an individual whose parental rights were involuntarily terminated. That's real clear. As it is now, there's no bright line right now. The previous cases have operated on principles, best interest, equitable principles, reliance, things like that are far more nebulous. This case provides more sharp, clear parameters. And
Counsel, are there any other questions? I think we understand your position.
Okay.
Thank you very much.
All right. Thank you very much, Your Honor.
Honorable Justices, I'm here to argue.
We're going to take a break.
Oh, okay.
I
We
didn't
haven't
call
called
the
the
next
next
case.
case.
I'm
yet.
sorry.
That's okay, all right.
I was letting counsel move away
Yeah,
from
this case will
council
be
table.
submitted. This case will be submitted. All right, we've got, just sit tight for a minute. We've got some folks coming to visit us, so we're going to get them in the room here real quick. Perfect attendance today, it looks like.
Looks like.
Let the record reflect that we welcome today Brenda Chris Keaton and the Wirt County Middle School students. And I made the comment up there, you may not have heard it, it looks like you had perfect attendance today. It looks like everybody showed up. We want to welcome you, and I'll let you know that after this case has been argued, we'll hang around and answer some questions for you, okay? All right. All right, Madam Clerk, call the next one.
The court will now move to the Rule 19 oral argument docket, in re KS, BM, and OS, docket number 20-1030, an appeal from the Circuit Court of Monongalia County, West Virginia.
Try this one more time now. Thank you. I represent the mother, SS, of 3 children with 3 different fathers. The court just heard the arguments regarding the child support for one of those children, KS. KS is now 12 years old. Her father is GH. That's a female child. BM is a male child. He will be 8 years old in 2 days, and his father is SM. And another daughter, OS, will soon be 5 years old. Her father is AW. This was a child abuse and neglect petition that was filed in the Circuit Court of Monongalia County, West Virginia, back on February 7th of 2019. Allegations had arisen of substance abuse in the context of a family court proceeding for visitation regarding the child BM, and parties to that proceeding were my client SS and the father of BM, SM. During the course of that proceeding, concerns were raised on substance abuse on the part of both of the parents, and the department was directed by the family court judge to investigate. And so that's how all of this got started. My client, nothing resulted with the investigation into the father SM at that time, but my client had some drug screens and tested positive for methamphetamine, and the department ended up filing a non-emergency petition. She agreed to let the children go with each of their fathers. She was never married to any of these 3 fathers. Prior to the institution of the abuse and neglect proceedings, she had been the primary custodian of all 3 children, and the children had never lived separately from each other. So, as I said, they were never in DHHR custody. They remained in the custody of their respective fathers throughout the entire abuse and neglect proceeding. And the only issue against her, albeit a large one, was her substance abuse. There were no allegations that she had physically abused them, deprived them of a proper home, had neglected them physically, anything of that nature. As a matter of fact, she was apparently a good mother because at one point in the past she had qualified as a kinship placement for other children in her home. The 2 issues that I raised in this appeal, and ultimately her rights were terminated to all 3 children, and the 3 children were placed in the exclusive custody of the 3 respective fathers, with discretion being given to those fathers whether there would be any post-termination visitation or not. My understanding is that she's not been seeing the children. After this case ended and my client's rights were terminated, there was a separate proceeding, as was updated by the department and the guardian ad litem in their updates regarding the children. There was a later proceeding filed against the father, SM, father of BM, and actually that was based on, to my understanding, on domestic violence and substance abuse issues on the part of that father. That father is now in jail, and the child is with that father's wife, who would be the stepmother of the child, BM. SM received a disposition 5 in his case. So the two issues that I have raised in this appeal are, number one, that the circuit court erred in finding that there was no reasonable likelihood that the conditions of abuse and neglect could be substantially corrected in the near future, and that termination was necessary for the welfare of the children. And number two, the circuit court erred by failing to implement a less restrictive alternative to termination, which could have been another improvement period or a disposition 5.
How many improvement periods had she had?
Well, that was a long shot on my part. I didn't think that was going to succeed because she'd had improvement periods in the past. She
had an improvement period, and if I recall correctly, 2 extensions?
She had a, well, first of all, she stipulated to the substance abuse, and then she got a post-adjudicatory improvement period for 6 months with a 3-month extension, and then because she was doing very well at various periods in the case, she got a dispositional improvement period. So this case, for more than one reason, dragged out for a fairly extensive period of time.
She had 15 months. She had 15 total months of improvement periods. Is that correct?
That sounds about right, yes. Okay. Yes. So, but it was complicated by the fact that COVID was going on during this period of time, which I'll get to on another issue in a minute. And also there was a change of judges, which caused a delay. And it caused a continuance of a hearing that put things off for several months.
Well, counsel, in your key argument under your first assignment of error, that there was no evidence put on at the dispositional hearing that could support the finding that the judge made. Is that what you're saying?
That's part of what I'm saying, yes, sir.
Was there a proffer made?
Well, there were arguments made that were somewhat confusing in nature by the prosecuting attorney representing the department.
Well, that's a different issue.
Right.
But the proffers were made as to what the current status was. Is that right? Of your client? Current status of your client?
Yes.
And did you object to that? Those proffers?
I don't recall exactly what the proffers were, but I put on 2 witnesses.
Okay, you put on witnesses.
Right, right. And my witnesses were my client's therapist that she'd been dealing with for a long period of time, who gave favorable testimony on her behalf, stating that my client started out rather slow and admittedly had a couple of relapses during the course of the proceedings.
Counsel, if you want to save any time for rebuttal, you've only got a couple minutes left.
Okay, thank you. One of the major issues in this case is that the department precluded my client from taking part in drug testing for a period from the Day Report Center in Morgantown, where she was being tested, closed down between the end of March of 2020 and did not reopen again until June 1st, 2020. After that, the department would not make the necessary referral for her to restart drug testing, because by that time they'd already made up their minds, contrary to what they had told me previously, that they were going to go along with the disposition 5. They then, in May of that year, changed their minds and said, we've staffed this for termination. So there was a period between the end of March of 2020 until we had the final hearing at the end of October that they did not set her up for any drug testing. They did not allow her any visitation with her child. The units for supervised visitation ran out, and they would not reauthorize any further visits. So that's a further complicating factor.
All right, counsel, I'm going to make you stop right now. I'll give you a minute or two to rebut, but you're at your 10 minutes right now.
Okay.
So, okay, let me hear from
Thank you.
the department.
Thank you, Your Honors. May it please the Court, my name is Katika Ribble. I'm an Assistant Attorney General representing the Department of Health and Human Resources here today. Children require stability, consistency, and reliability. Unfortunately, the petitioner could not provide for that for her children during the 21-month pendency of this case.
Counsel, what evidence was there for the court to make a finding that terminate?
At the disposition hearing, Your Honor? Yes. Your Honor, the court had the court summary from the department, as well as heard evidence from the petitioner and as well as her therapist.
I didn't understand you. The evidence petitioner called 2 witnesses.
Yes, sir.
What other evidence supported the termination?
The department did not present any evidence other than the department court summary report, which indicated that they were requesting termination of her parental rights. The court had access to all of the petitioner's drug screens and all of the visitation notes, which is what ultimately the court based her decision on. Also, the court had in its purview a letter written by KS in which she described how distraught she was because of the inconsistency of petitioner, inconsistency of her having visitations with them, phone calls, as well as drug screens.
Ms. Ribble?
Yes.
Why didn't the department put on any evidence at the disposition hearing?
Your Honor, I'm uncertain, as I was not a part of that part of it. I do know that the assistant prosecuting attorney relayed her personal opinion to the court, despite what the department position was.
Did the department decide not to put on any evidence, or did the prosecuting attorney decide the department was not going to put on any evidence?
I could not speak to that. However, I would state that being the assistant prosecuting attorney for the department, it would be her job to present the evidence on behalf of the department.
It would be her job to present any evidence that the department wanted to put on, right?
Correct.
So was it the department's position, notwithstanding what counsel represented, that the department supported termination, and is it, to my understanding from the record, that the assistant prosecuting attorney supported a disposition 5, is that correct?
That is correct. That was her personal opinion. However, the court in its discretion reviewed the file and made findings that there was no reasonable likelihood that the petitioner could change the conditions.
So what you had a prosecuting attorney standing in front of the judge saying, I think disposition 5 is what we need to do, and the department saying in their written documents, no, we think termination. So who gets to speak at that? Of what import was the assistant prosecuting attorney's opinion at all?
None, Your Honor. It was her personal opinion. And I do believe that the court made the sound finding in weighing in that opinion versus the evidence that was within the court file with respect to petitioner's progress through this case.
Well, you've got a statute. I think it's 49. 4501, it's been a long time since I've looked at it, and there's a court case. Jonathan G. wades into those issues. It says the prosecutor represents the department. And Jonathan G. says the attorney-client relationship is the same as any private attorney-client relationship. So would the prosecuting attorney's opinion have any impact whatsoever, or would that be like John Q. Citizen coming in and saying, hey, my recommendation is this or this?
Your Honor, the personal opinion of the prosecuting attorney should not weigh into how the court makes its decision. It would just be akin to a defense attorney representing a defendant in which they did not believe their client's position, however, went forth with what they were tasked to do.
Has the department changed its position at all from its original position that termination was appropriate at any time during this?
No, Your Honor, no. The department still believes that termination was appropriate and is still appropriate. This case, as petitioner's attorney advised, this case has been pending since January of 2019. The petitioner has not seen the children in 24 months, has had zero contact, zero visitation.
Is that
with these
because
children.
the department wouldn't let her?
Yes, Your Honor, and that was because of her failed drug screens. During the course of the case, she was given 2 improvement periods, 1 extension. However, she was inconsistent with her drug screens. There were times where she wouldn't show up. There was 1 period where she had 4 months of clean drug screens in which she was having visitation, and then she relapsed. There was a period of time in which she went into inpatient rehab for 30 days and ultimately relapsed after that. The MDT as a whole decided that this inconsistency for the children were not in their best interest.
What about counsel's allegations that DHHR shut her client off from any future drug screen?
Your Honor, with respect to that, the petitioner was in a Suboxone clinic, so she had the ability to obtain those drug screens from which they are required to do at the Suboxone clinics, and she could have provided those copies to the department. In fact, at disposition, she testified that she signed a referral, but she said, signed a letter allowing the DHHR to have that information, but she said she didn't know what else happened after that. So
she authorized DHHR to obtain her drug screens. She doesn't know whether DHHR did or not.
Correct, Your Honor.
Does DHHR have an obligation to follow up?
Yes, and I believe that was done. However, I don't have any documentation as to what they obtained or were able to obtain.
Because there was no evidence presented at the disposition. Is that a fair statement?
Well, the petitioner was cross-examined by all parties.
Yeah, but there was no evidence on that issue presented at
Not that specific issue, Your Honor. So with respect to the difference between a disposition, what is commonly referred to as a disposition 5 and a disposition 6 under 494604C6, the court made a finding that there was no reasonable likelihood that this petitioner could remedy the abuse that occurred. She made that finding, based on the fact that the case was pending for 21 months at the time of disposition. Her inconsistency, the letter that the court reviewed from KS that outlined her distraught in having to go see her mom, her inconsistency with making promises that she would visit them, give them gifts, that weighed in a lot as to the court's decision, and the court found that it was in the best interest of the children for her rights to be terminated. In fact, she said it would be detrimental to the children for them to be returned back to her custody because of her inconsistency.
I think we understand your position. We'll hear from the guardian.
Thank you.
Thank you.
May it please the court, in this specific instance, in my guardian ad litem report, I did also recommend a disposition 5. The reason that I had recommended that was because the children were all with their biological parents, and I had felt that permanency had been achieved. However, as the court lays out pretty clearly in the record why they did terminate her parental rights, I believe the court did not err in doing that.
So that's the reason your position today is different than your position was at the dispositional hearing?
That is correct, Your Honor. So as the court laid out certain evidence and facts of what had happened, and I believe the court did a very good job of starting from the beginning of the case and kind of going through each of the things that the respondent mother was supposed to do and things that she had failed to do. And in that evidence, she had continued to fail drug screens as she had relapsed a few times during these improvement periods. She did try to go and get help for those relapses, and she did attend rehab, but as soon as she was released from rehab, a couple months later, she would relapse again. And so there were times when there was inconsistencies in the drug screens. There were times when we would have MDTs that she would misrepresent certain facts. She would say she missed drug screens because she had employment.
Counsel, I don't mean to belabor this point, but at the time of the disposition hearing, you determined that it was your position that it was in the best interest of the children that the court order disposition 5.
That's correct.
That was your opinion as to what's in the best interest of the children.
Yes.
And you now have changed your opinion based on the content of the court's order?
That is correct. And the reason for that is the way that I looked at it was the children had permanency because they were with their biological fathers. So anything that the mother may have not done during her improvement periods, she could have, in my opinion, at that time, she could have gotten clean, came back on a petition to modify a disposition, and tried to get her custodial rights back. However, when the court put so eloquently in its findings all the issues that were raised and why the court was terminating her rights, I do believe the court did not err in terminating her parental rights, because I believe that even though, and after preparing for this appeal, there was case law that I also found that just because the child is with a non-abusing biological parent, a disposition 5 is not automatic. And for my practice up until that point was that if they're with a biological parent, a disposition 5 is the least restrictive alternative. But when I started researching and in preparation, and after hearing the court's findings, I believe that they were correct in terminating her parental rights, because just because the other biological parent has custody, it's not an automatic disposition 5.
Okay, well, counsel, along those same lines, when you said originally you thought that the best interest of the children was to have a disposition 5 because they were in the custody of one of their parents, but in fact now one of the children is living in the custody of a parent's girlfriend or fiance, and she's taken over as the mother figure. Is that true or not true?
That is correct. It is his wife. They are married, so she is the stepmother of the child.
So what would happen if the child looks at that lady that she's been living with now for going on 2 years as her mother? There could never be permanency because there could never be an adoption, correct?
So it's my understanding that there could be an adoption.
With a disposition 5?
Oh, not with a disposition 5.
That's what I'm saying.
Yes.
With a disposition 5, where you said you looked at that the children had achieved permanency, when in fact that child has not. Yes or no?
Yeah. So at the time of the disposition hearing, the children had achieved permanency because they were the child BM was with his biological father and his wife.
But been living with this. She'd been living with the wife for how many months since the beginning of the case?
He had been living with the wife since the beginning of this case, and so during that time period, the child had achieved permanency because he was with their biological father. Now, in the pendency of this appeal, there was that abuse and neglect that was filed against BM's father, and now, as I had stated, if the court would remand back and do a disposition 5 for the mother, then that would mean that the stepmother could not adopt. That's correct.
Anything else?
It might also mean that if the mother does clean herself up, she might regain custody.
That is correct. If she was given a disposition 5, she could come back to modify that disposition and regain custody at that time. But with her not having seen the child, I don't think it would be in the best interest of the child to go immediately back to the mother on a disposition 5 modification due to the fact that she's had no contact and this child is going to be 8 years old and hasn't seen his mother in over 2 years.
Thank you. I think we understand your position. Counsel, I'll give you a minute to wrap up.
I just want to say that one of the problems that we have here in assessing whether the mother should have gotten a disposition 5 at the hearing on October 30th, 2020, is that we had 7 months where nothing was happening, and the department, they didn't put on any evidence because there was no evidence of what went on in that 7-month period. There was no drug screening being done by day report, so that we had that 7-month period between the end of March until the disposition hearing at the end of October, in which the department can't say one way or another whether she's clean or not clean during that period.
Apparently your client authorized the department to have access to her drug records from the Suboxone clinic.
Yes.
Okay. So they would have had evidence that they chose to submit it.
Yes, yes. And I just want to say now we're in the unusual position where the father of one of these children now has his own disposition 5. Why should he get a disposition 5 and not my client? It doesn't make sense to me because his issues were the same. And the fact of the matter is my client was attacked. It was always 3-on-1, the 3 guys against my client. And she was looked at disparagingly by the department because she tried to raise issues about these fathers, and every time she did, they accused her of deflecting. Well, now it turns out that the things that she was trying to talk about the father of BM was true, because now it ended up in a substance abuse case on his part, but no one would pay attention to her at the time.
All right, thank you, counsel. I think we understand your position.
Thank you very much.
This matter will be submitted. Are we going to stay or go? Stay for 5 minutes, okay. All right, we're going to, counsel, if you want to leave, we're going to stay and talk to the students a little bit for just a minute and figure out what they want to know. Okay, thank you.
Thank you.
All right. Ms. Keaton, we have you here. These are 8th graders?
Yes, sir.
And so what's their purpose today to be at the Capitol?
They take a West Virginia history class with Mrs. Bubble, and so we bring them down to learn the 3 different legislation branches at the state level. And Justice Armstead is a friend, a family, and loves to have us down. So if you could just kind of give us an idea of what goes on at the state level of the Supreme Court. We would love anybody to have questions about what they heard. We would love to just have the knowledge that you all provide. And I will remind you, I'm meeting guys at the clerk of the court. You can't ask the justices questions about the case that you just heard. They're going to be deciding that case, okay? So feel free to ask them cases, ask them questions, but not about the case.
Not about the one you actually heard today, because we can't talk about it. What you hear here today, and then what you will notice with the Supreme Court, you'll notice if you've ever seen a courtroom on TV, you'll note that there was a witness stand and a jury box and all that kind of stuff. And you heard us talking about evidence today. Was there evidence? We deal here only on the legal issues that were raised in the court below. And you heard him talk about the record. The record is the documents, the testimony, the papers that were created in the court below. And we have access to that, and it's called the appendix record. We call it the appendix record. And we can only talk about and look at what is in that appendix record in terms of was something in the evidence or not. If it's not in our appendix, then it doesn't exist. We deal only with the legal issues. That's why you didn't see any clients here today. You didn't hear any testimony. Well, you may have heard some testimony, but it was in the form of an argument. Sometimes lawyers will testify, or try to at least, but we have to look over that. So we're the Supreme Court, and that's what we do. And the courts below, now there's a new Intermediate Court of Appeals that will be active July 1st that will hear the same kind of cases, only just a different set. They'll hear workers' comp cases, they'll hear civil cases, they will hear things from the Healthcare Review Board and all that kind of stuff. But then below that are the circuit courts. And this case that you heard today was from the circuit court because it dealt with abuse and neglect. And then below the circuit courts are the family courts that deal with family issues. And then below that are the magistrate courts in the state of West Virginia. Who's got a question? Yes, stand up and state your question. I'm having trouble. Can somebody repeat?
Can somebody repeat that for us?
She wants to know why the DHHR is not funded. I don't know that that's forced or not.
The one thing, I'm going to jump in and offer an answer. Hopefully what you've learned today is there are 3 branches of government, right? All the courts that you heard our chief talk about are in the judicial branch. And our job in the judicial branch is to handle cases, and our job in that branch is to hear the appeals of those cases. DHHR is over in the executive branch. And then the third branch, what's the executive, judicial, what's the last one? Legislative branch. Legislative branch decides how much money everyone gets. So what a really good place to ask that question would be over in the legislature, over in the Senate or the House of Delegates, because we do a lot of really important work up here, but we don't get to decide how much money DHHR gets.
I understand that my mom worked with the state for years, and she loved her job. She loved her children, she loved school and health, but it just got so tight on her. This was over 130 when she left, and she couldn't take it. She really loved the state. That was her dream.
But she's just telling us that they can't answer those questions.
We can't answer why there's no more money. That's not in our bailiwick. Who else has got a question? Yes, sir. Stand up and ask your question.
If I may ask, what's behind the curtains?
Awesome question.
Can I talk about the courtroom for a minute?
ahead.
Yeah,
Go
okay,
ahead.
because we love to talk about courtroom, so you ask a good question. We all come out, look around this courtroom and you'll see that this room is similar to another room that you may have seen on TV, and that is the United States Supreme Court chamber in Washington, D.C. And the exciting thing about it is people think, well, you all copied off of the National Supreme Court. It's actually the opposite, because this room was designed first by Cass Gilbert, and then he was hired to design the United States Supreme Court chamber in Washington, D.C. So we're pretty proud that this room is sort of the prototype, the first shot at that. So behind the curtain is just a hallway. We have a conference room over behind these curtains that we sit in and talk about the cases. Like we'll go in and talk about the case we heard today, all the cases we heard today. We'll go and discuss those tomorrow. And so when we come out of that conference room, we walk around this curtain and we all stand behind these curtains and come out together at the beginning of the first case that we hear. But there's really nothing but basically a hallway behind these curtains, except our conference room is back there in that room. But this room was designed by Cass Gilbert. If you look around the 3 walls that you can see here, the true foundation of Republican government is the equal right of every citizen in his person and property and their management That's an assurance that Cass Gilbert wanted people to see when they came in this room, that anyone that comes and has a case in front of us, we should treat them fairly, that's a basic right they have to be treated fairly. If we're sitting here hearing cases, we see the back, which says firmness in the right as God gives us to see the right, from Lincoln's second inaugural address. And that's a reminder to us to do the right thing, to be fair to the folks that we hear. And it's just sort of nice that we have the symbolism in the room here in this courtroom. So this is a beautiful courtroom. Like we said, if you see the one in Washington has 9 seats up here, but it's sort of, like I said, he took the first shot at designing this room and then used that design in Washington, D.C.
Good question. Other questions? All right.
Thank you very much.
Hey, we're so glad you could join us today.
Thanks for
Good to see
coming.
you
We
guys.
really appreciate it, guys.
Did you all go to the legislature already? Did you get to go down there and see them? Okay.
They called a bill back out to finance, so we had to sit and wait a long time and just wait to get introduced. So they didn't really get to see much action in the legislature office, but
All
they
right.
visited the governor's office and we walked around the building, and now it's time for us to go.
Okay.
Well, when we said we can't talk about the case, but we will issue an opinion in that case later in the sometime between now and the end of this term. And so that will be public, and perhaps your teachers can see that and share that opinion with you once it's decided, so you can kind of see how this case came out when it's done. All these arguments are open to the public, and you can, if you can't be here like this, you can tune in on the internet and watch the arguments. So hope you'll do that as well. Great to have you here.
Thank you.
All right, since there was a question about the curtains, I want to add an additional answer to that question. So Cass Gilbert is the architect who designed this courtroom, and he is the prime example of an architect who knew what this room was going to be used for, and it really works for its purpose. You can all hear me in here, and I am not talking on a microphone right now, right? So although there is all the marble around the courtroom, he installed a cork floor that helps to keep the sound into this room. There's the skylight, something else that might allow sound to leave the room. So Cass Gilbert put these heavy velvet curtains around the perimeter of the room to help keep the sound in. And back in the 1980s, the justices at that time decided that although you could hear very well in this courtroom, you couldn't see very well, especially on a cloudy day. And so they had the curtains taken down, because what's also behind those curtains are big windows. There are 3 big windows on that side and 3 big windows on that side, so the light can come into the courtroom if the curtains aren't there. But unfortunately, when they took the curtains down, it really affected the sound in the courtroom. And one other thing that's behind the curtains, there is a bathroom back there. We will resume with the Rule 19 oral argument docket this afternoon. Antero Resources Corporation versus Directional One Services Incorporated USA, docket number 200965, an appeal from the Circuit Court of Tyler County.
May it please the Court, Ansel Ramey on behalf of Antero Resources. I'd like to reserve a couple of minutes for rebuttal. This case, the importance of this case is beyond the parties and the issues immediately before the court. I think this case is important in terms of reaffirming the principles of contract law in this state. And I think it's important to go through just briefly the chronology of the contract documents. At Appendix 373, what happened was the respondent, Directional One, presented a directional drilling proposal to Antero Resources. That's dated August 25th, 2014. And the proposal had different prices, $79.95 for operational day rate, certain hole sizes, $42.95 for mobilization, demobilization, et cetera, et cetera. You know, it did also have replacement lost in hole prices, which are the subject of the litigation in this appeal. But finally, it had a number of other terms, general terms and conditions, so appear on page 380 of the appendix, acceptance of terms, indemnification provisions, et cetera, et cetera. So Antero receives this, dated August 25th, 2014. Now, from a contract law perspective, what happened next? Antero rejected that proposal and presented a master services agreement dated August 29th, 2014. And that agreement was signed by the management, the leaders of both of these organizations. And that is the agreement, from our perspective, that governs the dispute that's currently before the court. Page 448 of the appendix, the effective date is the meaning set forth in the preamble. The term work is defined on appendix 449, section 1.19. Work shall mean any and all services, labor, experience, expertise, vehicles, equipment, tools, supplies, manufactured materials, etc. Section 2 of the Master Services Agreement, this agreement shall control and govern the relationship of the parties, as well as any and all work accepted by the contractor for company from the effective date until the termination date. Section 5 of the agreement on Appendix 451, this is a key provision of the contractual relationship between the parties. Contractor's investigations. Contractor's acceptance of and or agreement to perform work means the contractor has and warrants that it has fully investigated and incorporated into the compensation, any rate schedule that is given, the complications, hazards, and risk and incident to the site and performing the work. What else did the Master Services Agreement say about that? Appendix 453, Section 10.1, the company will pay work that is satisfactorily rendered in accordance with this agreement in accordance with the public schedule of rates and or prices. Importantly, Section 10.4, except as expressly provided in this agreement to the contrary, the rates agreed to by the contractor shall be inclusive of insurance premiums paid by the contractor in acquiring and maintaining insurance acquired by this agreement. Now, why was insurance required under the MSA? To protect Antero. That was coupled with an indemnity provision, which is in Section 13 of the MSA. Except as expressly provided in this agreement, all indemnity and hold harmless obligations or liabilities assumed by either party of this agreement shall be regardless of cause. Now, what did Directional One guarantee in this MSA to Antero? In Section 13.3, the contractor shall release, protect, defend, indemnify, and hold company group from and against any and all claims arising out of or related to what? The damage to or loss of the property of any member of the contractor group, regardless of cause.
Counsel, can I just you mentioned 10.1. I know you've moved on from that, but if I could just ask you in that, it seems that in that language there implies that there is an order as defined in the definitions of this, and it says that at such rates and or prices as are agreed to by contractor and company in the applicable order. Was there any type of an order related to this particular project?
No, and you bring up an interesting point. They rely completely on this proposal, August 25th, 2014, that has provisions relative to lost and whole. That is the only agreement ever signed by Antero. Never signed an order, never signed any of these proposals. And if you look at the invoices that they presented that are the subject of this case, which appear at Appendix 609 and Appendix 618, you'll notice that the prices charged on the invoice for lost and whole equipment don't match this one. That's because subsequently there were similar ones of these issued that served as the basis for the parties going forward. But yes, there was no written order ever signed by anyone. Relative to insurance, Section 13.12 says the indemnity obligations under this agreement shall be supported but shall not be limited by liability insurance obtained for the benefit of the other party group as the indemnified party group with minimum limits and coverages required under Exhibit A. And 14.1 says the contractor shall at its own cost and expense carry insurance in the minimum amounts with the specifications and requirements set forth in Exhibit A. If you turn to Exhibit A, which is on page 463 of the appendix, this is clear and unambiguous. Contractor's minimum insurance limits, subsection G, first party property insurance covering for its full value the property, equipment, tool, and equipment of contractor group that is used in the work. Now, they make two arguments relative to that. Well, they make several arguments relative to that. One of the arguments is that once they lose the equipment in the hull, it becomes Antero's property, as if you hired a plumber and the plumber drops his wrench behind the wall and he says, well, you got to pay me for the wrench now because I dropped it behind your wall. I mean, to me, that's a silly argument. And they also argue that, well, Antero never, they had information regarding the insurance we purchased. None of the information relative to the information provided dealt with this first-party property insurance. And Directional One's own representative, in his affidavit, it appears on 488 of the appendix, concedes that insurance was available. Section 7, insurance for downhole tools is generally not available at a reasonable cost through third-party insurance providers. So that was a financial decision that Directional One made. And I wouldn't be standing here today had Directional One done what it obligated itself to do under the Master Services Agreement, buy insurance. Because insurance would have paid for the loss, and there'd be no dispute between the parties.
Counsel, why did in prior instances where there was loss of equipment, why did Antero pay under those? I mean, was that still under the same master service agreement, or was that a different?
All but one circumstance was before the master services agreement. There was one shortly thereafter that was paid. But of course, that's the reason you put the non-waiver provision. That's why this case is important from a contractual point of view. You've got a non-waiver provision that says if we pay something that we shouldn't have to pay, and then later we decide to contest it, we don't waive it. I mean, that's in every banking document, every commercial loan agreement. The other provision, two provisions of the contract I want to touch on briefly, and then I'll see time.
Before you do that, just going back to that same point, because I understand that there's the non-waiver, but if you have any ambiguity in the contract, it's sort of how the parties interpret it. So was there, and I think the respondent here would say, presume that custom of how that was done indicated how the parties interpreted this contract.
My understanding, it was one incident. It occurred shortly after the MSA was signed. And again, you know, Antero relies on the non-waiver provision.
Counsel, you've only got about a minute left. You want to save any of it?
I just want to address two other provisions, and I'll sit down very quickly. Section 19 of the MSA, the primacy provision, is critical to the case, and with all due respect to the trial court, just sort of glossed over it. If there are any conflicts between the provisions of this agreement and any order, work ticket, invoice, statement, published rate schedule, or any other documents, whether written or oral, the provisions of this agreement shall control. And then finally, Section 22 said, for this to be modified, it could only be modified in writing, signed by Mr. Onishenko and Mr. Shope, and that never happened. Thank you, Your Honor.
Good afternoon, everybody. My name is Chris Camper. I represent Directional One Resources. Directional One. With me is my local counsel, Lonnie Simmons, and also Kevin Onishenko, who is the owner of Directional One. Several things to clarify going to your most recent question about was there an MSA. The parties always had an MSA throughout their entire relationship. There was one that was signed in September of 2014, one that was signed in October of 2015. In all respects, material to this case, they're identical. There were 7 occasions where Antero paid for lost and whole tools, always under the identical terms of the MSA that they're now claiming released them from their obligation. So this is actually, when you get to the heart of it, a very simple case. There's an outer appearance of technicality and complication, but the fact of the matter is, once you cut through that, the parties had a very detailed and specific written contract. It encompassed 2 documents, a master services agreement and a rate sheet at all times. And that's about as complicated as this case gets. And why is that? Well, without the rate sheets, the parties would have had really no agreement whatsoever. The master services agreement doesn't even say what Directional One would do, how much it would charge, what services it would provide, what equipment it would provide, what were its wells plans looking like, how many people would it have on site. Any of the details or even the basics of the parties' relationship, completely absent from the master services agreement, only in the rate sheet. So they're trying to avoid their judgment here by denying that the rate sheet is part of the contract. So let's go through some undisputed facts, because I believe Mr. Ramey misstated the record in several respects. Number one, Antero signed this rate sheet back in September of 2014. All right, and they say this in their summary judgment brief before the trial court, and yes, they use the terminology rate sheet. This notion of calling them proposals is an innovation, I guess, they came up with for appeal purposes only. Throughout the entire trial proceedings, Antero used the same terminology, rate sheet. John Black signed it for Antero Resources, and that means he was authorized to sign for the company. Therefore, Antero Resources did not reject the rate sheet. It accepted the rate sheet by signing it. Next undisputed fact, John Black was authorized to sign for Antero. Here's what they say in their summary judgment brief. Black was a director of drilling operations. At the relevant time, he was responsible for operations in West Virginia and Ohio. That's at App 130, footnote 3. Next undisputed fact, Mr. Black was not field personnel. They raised that, kind of snuck it in a footnote in their opening brief before this court, and then made a bigger deal of it in their reply brief. Either way, it's contrary to undisputed fact in the record. Kevin Killstrom, Senior Vice President for Antero, was directly asked, is John Black a field employee? And he said no. That's at App 696. Kevin Onishenko also testified to this in his deposition at App 176. Both sides testifying to the same thing. It's an undisputed fact.
Counsel, I don't mean to interrupt you, but I guess I'm trying to see how we get around Section 13.3, the contractor's general indemnity provision that makes specific reference to the fact that your client would indemnify the petitioner for the damage to or loss of property of the contractor group. How do we? And why is that not dispositive of this action?
Sure, Your Honor. There's several reasons for it, and the court went into this in paragraphs 32 and 33 of its order at App 101, so it did not gloss over it. It's a very detailed discussion. There's 2 reasons. First of all, the Master Services Agreement says several matters must be dealt with in the rate sheets. For one of them, 10.1, as you pointed out, requires them to pay in accordance with the published rate sheet. Section 10.2 also says that the contractor may charge for materials and supplies as long as it is specifically stated in the rate sheet. Section 5 refers to compensation. It doesn't say daily rate. It says compensation, which must be provided, and the only place that was provided between these two parties was in the rate sheet. So those three sections all refer matters to the rate sheet, which Antero agreed to and signed. And Section 13 doesn't swallow those provisions whole. What those provisions do is they create an obligation on Antero's part to pay for lost and whole tools, because that's what the rate sheet said. Section 13 doesn't eliminate your own, you can't indemnify yourself against your own contractual obligation that you have freely taken on. Next point, second point, Section 13 is very generic and very broad. The rate sheets are extremely specific and detailed. They identify exact pieces of equipment and exact prices. The parties went through some lengths to negotiate a detailed, specific rate sheet. And why would they do that? And then, when they were doing that, they were creating an exception to the general rule of the Master Services Agreement. And that's quite a common thing to do. It's as common as saying there's no parking here except on Sunday. General rule, specific exception. That's all it is, and it really doesn't take a jury of 6 people to figure out what that means.
Was that rate sheet specific to this MSA, or was it a rate sheet that applied to other?
What happened was it was specific to these parties. It was issued and it was signed in September 2014, and it has a provision in it that says future prices can change on 30 days' notice. And 30 days' notice was given. I think there were 5 more rate sheets. In each case, the requisite notice was given, and the rate sheets were never rejected. And in fact, Antero admitted in discovery that it paid all the invoices based on the rate sheets.
I guess my question is that rate sheet specific to your relationship with Antero, or is that a rate sheet that would apply to other customers and other contracts?
No, it's specific to Antero. In fact, Directional One only had one customer, and that was Antero. All right. Now, the other misstatement of the record here we had was Antero argues that Al Shope is the only person authorized to sign the rate sheets. That is certainly not what Section 22 of the MSA says. Mr. Shope's name doesn't even appear in that provision. It appears in Section 23, which is the following one. And what that one deals with is not authority to sign an agreement, but that deals with notice. And all that says is that Al Shope's name has to be on the envelope when you're sending a notice to Antero. And that's irrelevant to whether or not he has authority to do or not do something. What Section 22 has a list of criteria for who has authority to sign on behalf of Antero Resources. And those parties, those criteria are easily met by John Black and several other people who also were instrumental in reviewing the rate sheets. It happens that Al Shope was also the director of Antero's procurement group, and that procurement group also did review and approve the rate sheets. James Harvey testified to that in his deposition, and it's an undisputed fact as well. The next undisputed fact is that Directional One provided tools as well as services. The court addresses this in its order. Page 9 to 10 of our appellate brief, we quote no less than 5 of Antero's senior executives and managers who all testified to this exact fact using that exact terminology. And the way the drilling operations would work is that Antero would take physical possession of the tools. Directional One shows up at the site and unpacks the tools. They're inspected. They are attached to a drilling rig which does not belong to Directional One. It usually belongs to a contractor. In fact, usually it's Baker Hughes. But it's operated and ultimately supervised by Antero, who controls the entire drilling operation. Once the tools go down the hole, Direction One has no control over them anymore. It's all up to Antero. And that's the sense that they took possession of it. That's within the meaning of the term provided. I provide you tools to use. The analogy to a plumber is just completely contrary to undisputed facts in the record. And John Black describes that in his deposition in App 420. And in fact, when these specific tools were lost, it was because an Antero employee had failed to follow directions from his boss.
Counsel, going to that point, let me ask you then, is that consistent with paragraph 6, that subsection I, contractor shall have full and complete care, custody, and control over all work and all other modalities of the work, the supervision and safety of all its personnel, and step-by-step details of the work. I mean, it sounds like you're saying that maybe factually they had, that Antero had control over, but under the contract, doesn't it say that your client had control over the work?
It does say that, and again, the Master Services Agreement is very broadly written. It doesn't really specifically apply to anything that parties actually practically did. The rate sheet, again, has the specific terms in it that apply to their relationship. Direction 1 is certainly responsible for its own employees. It tells them what to do, but while the tool is attached to the drilling rig, they are not physically in control of it. And really the point there is not an issue of who is responsible for what at that point. The issue here is were the tools provided to Antero, were they made available to Antero within the meaning of the contract? And that was the point I was trying to make with that argument.
What about the issue of insurance that Mr. Ramey addressed?
Yes, Antero had lots of insurance requirements, and Directional 1 purchased the insurance that it was told to buy. And in fact, it could not have worked, it couldn't have even shown up at a site without having bought that insurance. And Antero monitored this very carefully. Again, the procurement group, headed by Al Shope, monitored this through they had a web-based portal called IS Networld, which would give information to contractors about what they needed to do. It would tell them if their insurance was deficient, and Directional 1 never got such a notice. The insurance they had was approved by Antero.
All right, any other questions? Thank you, Counsel.
Thank you.
We understand your position.
I will be quick. Relative to people on the ground, their own proposal, they had 2 supervisors there when this was being done. That goes into Section 6, III. It's not like they just delivered tools and walked away. They've got people on the ground there supervising the work being done. Relative to insurance, it's critical. 13 is indemnity, 14 is insurance. Section 14.3. Notwithstanding any provision in this agreement to the contrary, failure to secure the insurance coverage, and the insurance coverage is for Directional 1's property, equipment, and tools. Failure to secure insurance coverage, the failure to comply with any insurance provision of this agreement, or the failure to secure endorsements on the policies as may be necessary to carry out the terms of this agreement shall in no way relieve the contractor from the obligations of this agreement. So, I mean, it's clear. Had the insurance promise been purchased, we wouldn't be standing here. If there's no other questions, thank you very much.
Thank you very much. The case will be submitted. Do you have a question? All right, okay. Go ahead. Thank you. Case will be submitted.
The final case for oral argument today under Rule 19 is Weaver versus Weaver, docket number 200690, an appeal from the Circuit Court of Barber County.
Go ahead.
Good morning, or afternoon now, I guess. Are you ready for me to begin?
Yes,
okay.
Go ahead.
May it please the court, my name is Phil Eisner, and I represent Harold Weaver, who is the original respondent herein. May I reserve 3 minutes for rebuttal, please?
Okay.
All right. First, thank you for the brief continuance from January until today, as we had a COVID outbreak in my office. I'm glad we're back and healthy and able to do this today. As I'm certain you all are aware, this case arises out of a petition for divorce in the Family Court of Barber County and the proceedings in order of the final hearing held on January 16, 2019 with respect to the trial on the equitable distribution of assets, spousal support, and attorney fees. Fortunately, no issues are before the court today relating to the parenting side of this case. We have raised 6 assignments of error in our brief. I will focus my presentation today mostly on areas 2 through 5, as I believe 1 and 6 largely speak for themselves. Briefly, assignment 1 deals with denial of a motion to continue the morning of trial as the result of an untimely disclosure of 60 pages of evidence. There is some dispute about the timing of when these were actually sent. I don't think that dispute extends beyond more than a few hours to the day before the final hearing, but by any measure it was late and it was difficult to review and prepare, and the amount of time allotted is certainly impossible to review with the client prior to proceeding to a trial the very next day. The second argument deals with the arbitrary assignment of values to real property when the court could find no competent evidence of its value. I think the family court correctly cited the Heffler case whenever it said in dealing with its equitable distribution section that the values of property must be based on credible evidence. And it correctly applied the law in this manner when dealing with the distribution of personal property. When it found no credible evidence offered by either party as to cars, tools, a bobcat loader, a mower, storage building, or car parts, the court ordered that those be sold, and that being that the best available method to determine what fair market value was. I believe that's consistent with 48-7-104 and the Whiting case that's been cited. Whenever it came to the real property, the family court used an entirely different methodology in determining value. Mr. Weaver has noted a couple times not to have presented evidence outside of his own testimony on the real estate issues and maybe some other items. This is precisely because he believed, and it was demonstrated through a testimony, that the petitioner could also not demonstrate the value of the items of real property at the date of separation. His position then and his position now is that the items should have been sold, just as the personal property items were in this case, when neither party had anything to offer other than their own testimony about the current value of the items of real property. The court chose to rely on a 10-year-old appraisal for the marital home, chose to rely on the amount used to purchase the restaurant in determining its value, and would not address the old appraisal or the appraisal of that restaurant from the past. And it would also, when we were dealing with the appraisal of the house, in contradiction to how it dealt with the restaurant, it did not consider amounts used to purchase when we were dealing with the house. They went back only to this appraisal, didn't take into consideration improvements that were done to the home and things of that nature, as it did when it evaluated the monies that were spent in starting the restaurant. And when we go down to the other real estate that was purchased during the course of the marriage, the court chose to rely on the property tax ticket. It did not consider, again, the purchase price, that is, it had done with the restaurant in question, and was just generally inconsistent with itself, I believe, in determining how it was going to value those properties. It's our position that those should have been sold in a similar fashion to what the court did with the personal property in this case. Assignment of Error 3 deals with petitioner being allowed to testify about the respondent being able to testify about the appraised value of the restaurant from an appraisal from some years back. While the court allowed the petitioner to testify on value of items like cars, just as an example, when she clearly stated in her testimony she was just guessing, the court would not allow the respondent to testify about his recollection of the results of a commercial appraisal to support his position on its value. And I'll point out that, incidentally, that's way closer to the purchase price that the judge used in determining the value of the restaurant. The only objection raised at the time was the best evidence rule. Hearsay is talked about in the respondent's brief at this level, but I believe that's waived as it was not referenced before. And I would assert, as it relates to the best evidence rule, that Mr. Weaver was not testifying as to the document. He was testifying about his memory of what an appraisal yielded about the price of and the value of the restaurant. Assignments number 4 and 5 kind of run together. The first deals with the arbitrary date of February 28th or March 1st when the court determined that it would change the status of certain payments that were made during the course of the divorce. At the very beginning of the case, there was an order entered by agreement that said that Mr. Weaver would continue to pay $3,500 a month to the petitioner, and the court would later categorize how that money should be divided as between spousal support, advance equitable distribution, and child support. the end of the case, the court did an accurate calculation consistent with the law for prospective permanent spousal support, in which the finding was that $350 was the appropriate amount, which we find hard to juxtapose against why a $3,500 amount was an appropriate amount for temporary spousal support prior to what we believe is an arbitrary date of February 28th or March 1st. The court also found that Mr. Weaver had claimed to be paying $3,500 from the retirement account, but offered no evidence to support that at trial. We would argue that it was well established in an earlier hearing in April of 2018, April 5th, I believe was the hearing, April 19th, the order entered, in which the court designated a Social Security check that was received for the benefit of the children as child support, and allowed Mr. Weaver to pay a lower amount, reduce the $3,500 amount he was paying by the $1,148 they were receiving in Social Security benefits and counted as child support, so that he would have to take less money out of his retirement account to satisfy that $3,500 a month payment. By this point in the case, it's obvious that Mr. Weaver was receiving Social Security disability benefits. I don't think it's plausible for anybody to believe he was able to pay $3,500 a month from some source other than the retirement account or the IRA based on what his income was at that time. So we believe that he should receive credit for all that he paid from the retirement account as an advance payment of equitable distributions, not as temporary spousal support prior to the cutoff date of February 28th or March 1st. The assignment 5 deals with the IRA in question. Mr. Weaver was undisputed, was a member of the union. Both parties testified to that, International Brotherhood of Electric Workers, and he had worked for them a number of years prior to the marriage, during which time he made contributions to the retirement account. His testimony was 1979, her testimony was 1984. In any event, either 24 of the 38 months this account was paid into, or 19 of the 38 months this account was paid into, were not done during the course of the marriage and should be treated as a separate asset of Mr. Weaver.
If you want to save a couple minutes, you better wrap it up.
Yes, sir, I will. Thank you. The court was not able to do a quadro for this account as she was for the pension plans, which were similar, because the parties had by joint agreement rolled over the original IRA into a separate IRA during the course of the marriage. So it made it a little bit more complicated to figure that out. So, and as it relates to the attorney fees in assignment area 6, the brief, I think, speaks for itself.
Thank you.
I apologize to the court. I had COVID during the last few weeks. I am COVID-free, but I do have a bit of a lasting cough, so hopefully you can understand me. May it please the court. My name is Shannon Thomas, and I am here on behalf of Barbara Weaver. The facts are actually not very contested. The wife presented about 200 pages of disclosure during the course of the divorce action by the filing of financial statements and then supplementals. There was also discovery that was requested by the husband from the wife, and it was approximately a couple of hundred pages that were also provided in discovery. In the disclosure of the witness and exhibit list, those items were referenced that they were going to be included in the evidence in the petition or in the meeting the court's scheduling order for the disclosure of the witness and exhibit list. However, on the 14th, we had a 2-day trial, so the court knows. 1 day was set aside for parenting and 1 day was set aside for the financial issues. On the 14th of January of 2019, counsel did meet and discuss, and I was requested, because I did have them labeled now, which they had not been labeled when I had originally submitted them. So I did, the day before court, as a courtesy to counsel, send him a copy of the exhibits. However, they were exhibits that had already been provided. And in fact, fact, in the motion to continue that was filed with the court, the motion notes that most of the documents had been already provided. However, there were 3 pages, I believe, that he objected to. Those 3 pages were the demonstrative exhibit that I had prepared to assist counsel, the parties, and the court in following along with the assets and debts. The court ruled that that was not going to be evidence, that that was a demonstrative, that in fact she didn't use it even in her, when the Honorable Court did her ruling, but she allowed it to be filed with the court just to help the parties follow along, because there were a lot of assets and debts that had been moving around. And in fact, counsel utilized that demonstrative exhibit as well. The court did not grant the continuance, and the circuit court affirmed that based upon Rule 19 of the West Virginia Rules of the West Virginia Rules of Practice and Procedure for Family Court. That requires a motion to continue to be filed at least 7 days before in writing or in under exigent circumstances to be determined by the trial court judge. After hearing the arguments of both sides that the exhibits had been provided previously but were only provided in order, the court ordered, Judge Johnson ordered, that the trial was going to proceed. This case had been pending for over 2 years. And quite frankly, Your Honor, I had only been in the case for about 3 months. I was a substitute attorney, and she felt that if I was up to speed, everybody should be up to speed and we should be ready to go. She allowed an objection to occur on each individual exhibit that was being offered, so that if it had not been properly presented or provided previously, it could be objected to, and the court could rule on each exhibit individually rather than continuing the trial. That was done, and I will note the court in her final order, which is 44 pages plus, I believe, 6 additional attachments, which includes her equitable distribution chart. She includes 23 exhibits that she admitted into the evidence. As there's no argument about any of those 23 exhibits that the court relied on specifically, it appears that the request for a continuance is moot because the evidence was not objected to during the presentation of the hearing. The remainder of the arguments, except for one, are really factual arguments, Your Honor, and I want to bring to this court's attention that when someone is requesting that the court review the findings of fact of a court or the factual issues presented in evidence, that this court must find that the court erred clearly erroneous. That's the standard, which is a higher standard. On each one of these issues, and I will start specifically with the real estate, so the court knows, and if you just read the 44-page order from Judge Johnson, you will see repeatedly that the issue was that the husband did not disclose the assets. He filed a very cursory financial statement that did not list all the real estate, did not list the vehicles, did not list his tools, did not list his retirements. Discovery was procured. There were still problems. There was good faith letters. There were motions to compel. And ultimately, counsel is correct, a release was signed to allow prior counsel to get access to the retirements. Unfortunately, that release was not honored by the union. Regardless, at trial, each party, as this court has said in Wilson v. Wilson, a 2010 case, the Mayhew case, the 1999 Mayhew 2, as well as Murray v. Murray, which is a 2013 case, each party has an obligation to bring forth evidence for the court to consider. So the arguments here today are basically, I didn't offer evidence, but I'm wanting the court to find that there was an error, because repeatedly in the order, the court finds that the husband did not offer evidence. In fact, he offered no documentation at all. He offered his testimony, and the court found that in comparing the testimonies, they didn't match, and she had issues with credibility as a result of the husband's failure to provide documents and providing misinformation to the court during the hearing. So the court weighed that evidence and made decisions. Regarding the last marital residence, that residence was the wife's prior to the marriage. There was an argument of whether it had become marital. It was determined it had become marital. The court cited the Whiting case and said it had become marital, but it was her home and the home of their minor children. So the court gave her possession of that home. There was an appraisal that had been offered of $205,000. Each party then offered testimony saying, well, there were improvements made. Well, that dissipated the value. The improvements weren't done. The house is falling down. The court heard the testimony and said, I can only decide that the value was $205,000. No one offered any evidence to change that value, and that's the value she uses, and she uses a lot of findings. Regarding the value of the business, Specifically, the court looked at not the value of the purchase price. The purchase price was $25,000. The court used a value of $185,000, which was as a result of looking at loan documents which were adopted by the court.
So I have a question about this restaurant.
Yes.
What, as I understand it, there were fairly broadly different valuations provided by the parties of the restaurants. Like
Yes.
From $75,000 to $350,000.
Yes, Your Honor.
What authority does a family court have to choose some other number besides the evidence that's presented?
Well, actually, Your Honor, she used the evidence. The $185,000 came from a loan that was obtained to redo, or based on the value to, so it was $25,000, and then there was a loan obtained, and that was the evidence, and I think that's also in the court's order, and that's how the court came with the $185,000. The court said that she did not believe my client because more money went into the property than the value my client was putting, but she also didn't believe the husband because the value seemed really exorbitant based upon his testimony. So the court, quite frankly, a trial court can only use the evidence that's presented. And in this case, I wish I'd had the funds to get more appraisals and to get things, I guess, better organized. But in the time period that I had, we presented what we had, which was the bank documents. And even though I didn't agree with the value in the course, the court determined that that was credible evidence of the value. So if the husband now wants to argue that, then the question is, why didn't he offer evidence? Now, regarding...
Just to be clear, though, there was no evidence that the restaurant was valued at $185,000. The family court did its own financial analysis of the evidence that was provided and came up with that.
The court looked at the bank records and determined that that was the value.
And what is the authority for the family court to do that?
I think the court has the right to look at the evidence that is offered and determine, for example, if you have two competing appraisals and this one has a mistake and this one has a mistake and you hear testimony on why those are mistakes, I think the court has the ability to weigh that evidence and make a determination. And that's what she did here because she's the finder of fact. She has to make that decision. And I think if the parties create an error, you can't then later argue that the error was created.
When you say the court looked at the bank documents associated with that, was there an appraisal?
The bank had put an estimated value, but there was not an appraisal, which actually is what resulted in the dispute over the best evidence rule. I had never seen an appraisal. One had not been exchanged during the course, and in the middle of the trial, the husband starts quoting an appraisal. I objected and said I didn't have it, I don't know about it, and argued best evidence rule. And contrary to counsel's statement, I did say, and by the way, it's also hearsay. I will admit I did not argue that as strenuously as I did the best evidence rule. However, Rule 1002 says that the original document is required if the content is what is being offered. And here, obviously, the content was the value of the restaurant. I couldn't defend that or even argue that because I hadn't seen it, and he could have made up any number he wanted. So the court properly did not allow him to testify from that, but did allow testimony on the $350,000. The court just did not find it to be valid based upon the woeful answers to the financial statement and the answers that he provided. Then you must look at the secret property, and that wasn't discussed by counsel. However, husband went and bought an item of property and then gave it to his son, and then claimed it wasn't his, but he lived there, and the son didn't. And he put all this money in the home, and then he said he was giving his son money as his executor. I don't know what that meant, but that's where he said that all of his money had gone, was he had given his son over $100,000 as his executor during the course of the divorce. The court found that his argument that he paid, I think it was $12,000 on a quick sale, did not match the courthouse records, which reflected, we argued, $120,000. The court said she looked at the documents and calculated it at $65,000. She said I miscalculated it. I've looked at it again. I still disagree with her. However, I do see where she got the number. She got the number in looking at the actual courthouse appraisement, because I couldn't get an appraisal of that property because someone else owned it. And the husband didn't disclose it, denied, and actually said, I quote, "It's none of her business." So the court did determine that was marital property and did put a value on that.
Is that evidence she relied on part of the record?
Yes, it's actually in the 29 exhibits that were filed with the court that she admitted and is referenced in her order. She also references the specifics of how he hid the property, and he didn't think she needed to know anything about it. The last couple of arguments I will go through as quickly as I can. The date of the temporary spousal support ending, I want the court to know that the temporary spousal support...
Your time is up, ma'am.
I'm sorry.
Go ahead and close it up.
Okay, I will close up. The temporary spousal support started or ended after the court entered the order, concluded the presentation of evidence. Trial ended January. February, she got proposals. March 1st was the new start date. The IRA, husband offered no evidence on it, none, zero, no document, so the court said she couldn't decide that, and attorney's fees, the judge made her findings. Really, the issue here is, Your Honor, evidence wasn't offered, and now they're appealing that. If you don't offer the evidence before the trial court, you can't argue later that you should get the benefit another chance. Thank you.
Thank you. Got about a minute.
I'll just quickly address the point about the restaurant, I'm sorry. The family court found that the restaurant was initially purchased for $25,000 on a credit card. There was a $150,000 initial construction loan that was taken out. Then after that, there was an additional $185,000 loan taken out for equipment, and subsequent to that, there was $10,000 that was spent on siding. This came up to $370,000. So the courts quite simply didn't buy the argument that it was only worth $75,000, as was suggested by the petitioner. The court rejected the argument of Mr. Weaver that it was worth $350,000, but his number was clearly closer to the totality of what was spent on the purchase of that restaurant. But the court came up with his own number somewhere in the middle, and I tend to agree. I don't know where the authority is to do that, and I think that that's part of my problem is the disparate ways that the court used to come up with the value of each of the three properties, none of which seemed to have a lot of credible evidence presented by either side about their current value at the time of the final trial. Thank you.
Thank you. Matter will be submitted.